Okay, it looks like we are coming close. We're just confirming that every court has no conflict. And we do have, I think, 4 jurors here, so that's good. All right. Okay, thanks everybody for your patience. We have gotten the okay to go. So I guess we're going to start, and I will call the case of State of West Carolina versus Timothy Ray. My name is Judge Goss. That's Goss. Scoring judges, if you could look at and I'm going to read off of this because everybody's got to do it the same. Yeah, it looks like y'all have already done it, but if you could please look to the 2 buttons on the lower left, turn off your audio video. It looks like the scoring judges have done that. They should remain off until the trial ends. So you should also have your video set to hide all non-video participants. So if you haven't done that, do that now. And so what that should do is the only people on the screen should be the advocates and should be me, I guess. So right now, can the attorneys in the case please make their appearances?
Good afternoon, Your Honor. My name is Megan O'Connell, and I am joined by my co-counsel,
Graham Marcus.
Together, Your Honor, we represent the state of West Carolina in this matter.
Okay, and for the defense?
Good afternoon, Your Honor. My name is Trey Allison, and I'm joined by my co-counsel, Alex Ephraim. We are here representing the defendant, Timothy Ray.
Okay, and as I can see, it looks like your names are all up there, which should make it easy for our scoring judges. And I guess for me when I need to address you. So we're about to hear the opening statements from each party. Everyone should make sure that they are in speaker view. So go ahead and do that now if you haven't. That button's in the upper right hand of the screen. And also, advocates, make sure that you mute your audio when others are speaking. You need to be muting your audio and video unless you are the advocate that is speaking or unless you are the advocate that is going to do that same role, either the direct or the cross or the other opener, if that makes sense. Everybody clear on that? Okay, so who is going to be doing the opening statement for the prosecution?
I will, Your Honor. However, prior to proceeding, we have a few preliminary matters to address with the court outside the presence of the jury constructively.
That is fine.
Would Your Honor like a brief summary of the case?
No, I don't need one. Thank you.
Yes, Your Honor. It's our understanding that the federal rules of evidence and federal rules of criminal procedure apply to this proceeding. Accordingly, pursuant to Federal Rules of Evidence 615, we ask the court to invoke the rule of sequestration and have all witnesses, with the exception of the defendant and the expert witnesses, constructively excluded from the courtroom at this time.
All right. Do you have any objection to that, Mr. Ephraim?
No, Your Honor.
Okay. So my understanding is that both experts will remain in the courtroom and that the defendant is, I guess, constructively present. And I will let, just as a note, and you may have gotten this in the judges meeting, but for our scoring judges, since there is not a defendant, I think that they will have constructively, the prosecution will have constructively been understood to have identified the defendant at some point during their trial, satisfying that element, since there won't be anybody to point to. But yes, that is fine. The two police officer witnesses will be excluded until they testify.
Yes, Your Honor. And additionally, we anticipate the parties will make objections that ordinarily would require us to approach the bench. However, due to the electronic nature of today's proceedings, may we ask to approach the bench, but remain in the shared viewing screen so that this particular jury may have the benefit of hearing our arguments.
Yeah, so anytime, all I ask y'all to do is just let me know that this is something that would normally be outside of the presence of the jury. But of course, we want our scoring jurors to be able to hear your arguments. And so as long as I understand that this is something that you guys understand would normally be at sidebar at approaching the bench. Thank you.
Yes, Your Honor. Prior to trial, the parties have entered into several stipulations found on page 5 of the case file. Does Your Honor have a copy of the case file?
I do.
Your Honor, at this time, we would like to call the court's attention to stipulation 4 on page 5. Specifically in regards to exhibit 6 and 8, the parties have agreed that these exhibits are admissible, and we would ask to move into evidence what's been pre-marked as exhibit 6 and 8, as states exhibit 6 and 8 at this time.
Is there any objection, Mr. Ephraim, to them moving those exhibits into evidence? I guess, first of all, have you stipulated that those are admissible?
Yes, it is stated in the case file that we have stipulated this, and I can confirm that we have.
Okay, now do you have any objection to them moving it into evidence at this time?
Not those exhibits, no.
Okay, that will be allowed. Are they going to keep their same markings? It'll be 6 and 8?
Yes, Your Honor, states exhibit 6 and 8.
Okay, exhibits 6 and 8 are admitted pre-trial.
Finally, Your Honor, the state now has one motion in limine. Would Your Honor like to hear this motion now?
Sure.
Your Honor, for the state's motion in limine, we move to exclude a portion of the testimony of Officer Peyton Wentz. Officer Wentz is the officer who stopped the defendant at the DUI checkpoint on October 19th of 2018, where he was later taken into custody. We anticipate the defense will elicit testimony from Officer Wentz that the defendant was having a mental type episode, experiencing delusions, and acting crazy on that particular night. This testimony, however, goes beyond mere observations and goes to the ultimate issue in today's case, which is required to be determined by the expert witnesses, which Officer Wentz will be unable to satisfy the requirements under Federal Rules of Evidence 702. For these reasons, we request the court grant our motion in limine.
Okay, thank you. Mr. Ephraim, you have a response to that?
Your Honor, I do object, and under the rules of the court, it is understood that the person who is going to address the issue that the motion is about will get to argue it. And so at this time, I'd like to bring forth my co-counsel, Trey Allison, to argue this motion in limine.
Sure, that's fine. Mr. Allison?
Yes, Your Honor. Your Honor, we oppose this motion. Officer Wentz's testimony without his prior experience and training as context, as well as his thoughts, takes away a valuable portion of his testimony as far as it goes to being probative to proving Mr. Ray's mental state at that time. And his thoughts and training and experience also help shape the course of the investigation. So we oppose the motion to limiting Officer Wentz's testimony at this time.
Okay, Mr. Allison, could you briefly address the, I guess what she said is that the observations that I guess the statements that he makes about the strange behavior of your client goes further than his expertise or goes further than his training and his experience. What is your response to that?
Your Honor, I plan to lay foundation about specific mental health training that he's had in relation to his training as a police officer. Nothing will go outside the scope of that training. Any observations and thoughts that he has are not a sort of expertise opinion, merely just his lay observations and how he was reacting to the observations he was making at that time.
Okay, Ms. O'Connell, last word.
Yes, Your Honor. Defense counsel will be unable to lay the necessary foundation under Federal Rules of Evidence 702 to qualify Officer Wentz as an expert, to qualify him to give the opinion as to the defendant's mental health. We're not objecting to Officer Wentz testifying to the things that he observed on that particular night. However, to allow Officer Wentz to give an opinion as to the defendant's mental health, meaning he was paranoid or crazy, is inappropriate for the jury to hear and is really reserved for the expert witnesses in today's case.
Okay, so here's what I'm going to do. I'm going to deny the motion. I will allow Mr. Allison. I will allow you to lay the predicate. I'll also allow the defense to, in their opening statements, refer to those things that if they need to. However, Ms. O'Connell, it's well taken that if they do not, if they are not able to provide that predicate at that time, then you are free to object, and I will rule on it at the time. So go ahead and lay the predicate as you normally would. And if she has an objection to that at the time, then I will hear the objection.
Yes, Your Honor. And with that, the state is ready to proceed.
All right. Is there any housekeeping from the defense?
Your Honor, would you prefer us to tender our expert witnesses or simply move on and let the trier of fact determine their credibility?
I think in many jurisdictions, it's not typical for a judge to accept a tender and to I guess accept an expert. However, since we are under the federal rules, and that is what they do in federal court, I would like you to tender the expert for my consideration. I'll allow the other side to make any arguments that they may have to the expertise, and I will, if I accept that expert, I will say so, and they will be accepted as an expert if you prove that person out. Anything else from the defense?
No further matters. Thank you.
Okay, then at this point, just making sure that our timekeepers are ready. I know that each team is keeping their time as well as the other team's time. So for the timekeepers, we will be starting the prosecution's opening statement at this point. So I will invite Ms. O'Connell to make the state's opening.
Yes, Your Honor. May it please the court, counsel, members of the jury. Punishment was his priority. On October 17th, 2018, 6-year-old Nathan Ray started his day eating his favorite cereal, Frosted Flakes, and a glass of apple juice to go with it. That morning, Nathan was supposed to go to school like every other child his age. But members of the jury, Nathan didn't make it to school that morning. Instead of sitting in his classroom, his lifeless body laid wrapped in a garbage bag in the trunk of the defendant's car. Members of the jury, fathers are supposed to protect their children. Their hands being used to hold them, to love them, and protect them. Instead, they were used to murder 6-year-old Nathan Ray on October 17th, 2018. On that morning in October, when little Nathan Ray spilled his glass of juice on the defendant's computer, what was the defendant's first reaction? I knew I needed to punish him for spilling his juice. Punishment was his priority. Jumping jacks, high knees, running in place, Nathan screamed and cried, begging his father to stop making him do the exercises. But members of the jury, Nathan, a 6-year-old child, didn't have a choice. Don't stop until I say so. Those were the defendant's words to Nathan. Eventually, his body couldn't take any more. The defendant walked to his bedroom and grabbed a belt out of his closet. But before going back into the bedroom to punish Nathan with that belt, the defendant took a moment to stop and think about what he was doing, what he was about to do. He tried to calm down, But what you'll hear today is that he didn't. His priority wasn't to calm down, to stop himself from what he was about to do. No. Punishment was his priority. Seconds later, the defendant wrapped that belt around Nathan's neck and pulled until Nathan stopped screaming, until he stopped moving, and until he stopped breathing. As the prosecution, we've brought charges against the defendant for the murder of his son, Nathan Ray. The defense has pleaded not guilty by reason of insanity. And what that means is that the defense must prove to you by clear and convincing evidence that when the defendant murdered his child, he didn't understand right from wrong. And as the prosecution, we have to prove to you today that the defendant is guilty of first-degree murder beyond a reasonable doubt. But members of the jury, your job here today is not to search for reasonable doubt, but to search for the truth. We ask you to remember this throughout today's trial. To meet our burden, we will call 2 witnesses. First, you'll hear from Detective Blake Booth, the lead detective in this case, who interviewed the defendant just 3 days after the murder. She will tell you that the defendant admitted to killing his son and described in detail how he committed this brutal murder. For 3 days after he committed the murder, the defendant drove around with the body of his 6-year-old son in his trunk. Members of the jury, you're going to see some Google searches today that the defendant made just a day after he committed the murder. Those searches are countries that don't extradite for murder. Will bleach destroy a body? And how to get rid of a body. You'll next hear from Dr. Mac LaGreca, an expert in the field of forensic psychiatry, who will tell you that although the defendant was depressed, angry, and anxious, the defendant did not and has never had any severe mental disorder, including schizophrenia. You'll learn today about malingering, which is when someone fakes or exaggerates their symptoms. And you'll learn how that played a role in this case. And at the end of today's trial, my co-counsel will come before you and review all the evidence presented to you today. And when he does, it will be very clear the verdict you should deliver. One that shows that on October 17th, 2018, punishment was the defendant's priority. And as a result, 6-year-old Nathan Ray is dead. And at that point, we will ask you to find the defendant guilty of first-degree murder. Thank you.
Thank you, Ms. O'Connell. Mr. Ephraim, do you have an opening statement from the defense?
Yes, Your Honor.
You may proceed when ready.
Please report. Opposing counsel. Eileen Sachs wrote that the schizophrenic mind is not so much split as shattered. It's like a waking nightmare. My name is Alex Ephraim. My co-counsel is Trey Allison, and the onus is on us to show clearly, using convincing evidence, that Mr. Ray is not guilty by reason of insanity. Mr. Ray first heard voices that no one else could at the age of 10 years old, brought on by his schizophrenia, triggered by the fear and the abandonment caused by his mother leaving. He would fight these voices, his schizophrenia, periodically. He would deny his illness, but his schizophrenia progressed. The voices dictated more of his reality, and eventually he would no longer know right or wrong. Mr. Ray committed this heinous act, but by the letter of the law, one must find that the defendant is not guilty by reason of insanity if they find the following 3 statements met by clear and convincing evidence. First, that Mr. Ray suffers from severe schizophrenia. Second, he was insane at the time his son died. And third, that due to Mr. Ray's schizophrenia, he could not appreciate the difference between right and wrong, or appreciate the wrongness of his acts the morning of October 17th. Mr. Ray is sick. He has been sick for a while. Ladies and gentlemen, his schizophrenia progressed. The voices dictated more of his reality until he no longer knew right from wrong. You're going to hear from prosecution's expert witness today, Dr. LaGreca. The facts will show that Dr. LaGreca's assessment is wholly inconsistent with the record. The fact is, Dr. LaGreca's assessment was made without ever once speaking with Mr. Ray or any of his family or associates, and is based primarily on secondhand knowledge and a good bit from Dr. Riley's report. Luckily, you're going to hear from Dr. Riley, who has actually sat down with Mr. Ray to let us know what is happening inside his head. What happened is his schizophrenia progressed. The voices dictated more of his reality until he no longer knew right from wrong. Both experts are going to discuss the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, the DSM-5. This is the authority on schizophrenia and outlines the process of diagnosing someone with schizophrenia. Dr. Riley is going to walk you through how Mr. Ray was exhibiting symptoms such as hallucinations, delusions, and negative symptoms. How Mr. Ray suffered from psychotic episodes brought on by disturbances. How Mr. Ray had no underlying medical condition and no evidence of substance abuse, and how this completes his diagnosis of Mr. Ray's schizophrenia. You're going to hear from Officer Wentz. Officer Wentz today. Officer Wentz was the first person in contact with Mr. Ray after the death of Nathan. He's going to discuss these negative symptoms, how Mr. Ray had a disheveled appearance, stains on his shirt, a strong body odor, that he was acting erratic, he was acting frantic. You're going to hear about how Mr. Ray thought there were CIA sirens, how he thought Officer Wentz was part of the CIA. Luckily, Officer Wentz's crisis intervention training kicked in, and at this point, he thought Mr. Ray was exhibiting signs of severe mental distress that were consistent with requiring medical attention. You're going to hear Dr. Riley discuss his first meeting with Mr. Ray back in April of 2010. At the time, Dr. Riley was part of a small team overseeing roughly 20,000 troops to determine frontline readiness. Mr. Ray's commanding officer committed him for evaluation because he had caught him seeing things, hallucinating. Dr. Riley is also going to discuss how in 2015, Mr. Ray's paranoia shifted towards his marriage. His auditory hallucinations, his schizophrenia, began pushing the idea that his wife was cheating on him. Mr. Ray's ex-wife, Jessica Ray, talked to Dr. Riley and described him as always having issues with mood swings. This is similar to Mr. Ray's father's description of Mr. Ray's mother. Jessica Ray, his now ex-wife, told Dr. Riley that over the course of their marriage, he became more and more isolated, would go a week or more without showering, and would lock himself in the bathroom for hours and refuse to come out. Then, by 2017, Jessica Ray described Mr. Ray as becoming a completely different person. Negative symptoms, hallucinations, delusions. His schizophrenia had progressed, the voices had dictated more of his reality, and soon he would no longer know right from wrong. Dr. Riley also separates the difference between violent and non-violent schizophrenics. You will learn that Mr. Ray, in early 2018, slammed a fellow employee against the wall and threatened their life because they weren't following the boss's directions. But Mr. Ray did not get in serious trouble, when perhaps he should have, because he needed serious help. Finally, Dr. Riley discusses whether or not someone who suffers from schizophrenia is able to distinguish right from wrong or understand the wrongness of their acts. This is what brings us to the morning of October 17th. Mr. Ray is struggling with the voices in his head, with his schizophrenia. First, he was cheated on. Now, he knows that his son is conspiring with Jessica. The voices said so. Mr. Ray fought this, but it doesn't change the fact that Mr. Ray went to his room. He grabbed a belt and he strangled Nathan. He would drive around with Nathan's body for 2 days before burying him in a shallow grave. He thought that the CIA was after him when Officer Wentz detained him. He thought the CIA was Mr. Booth, or was Officer Booth. He thought that Dr. Riley had a CIA camera in the microwave during the only time he has spent with a forensic psychiatrist since his arrest. It will become clear to you that Mr. Ray suffers from severe schizophrenia. It will become clear to you that Mr. Ray is violent. It will become clear to you there is convincing evidence that Mr. Ray did not understand the wrongness of his acts the morning of October 17th. Mr. Ray is the person that we must hold accountable for the death of Nathan, but by the letter of the law, we must hold him accountable in the right way. And that is why my co-counsel and I today will ask you to return a verdict of not guilty by reason of insanity for the reasons given. Thank you.
Okay, thank you, Mr. Ephraim. At this time, I will invite, hold on, I actually had, sorry, I had something I need to read to you before the witnesses. Okay, yeah. So before the state calls the first witness, I will ask everyone to switch to gallery view. Button is in the upper right of your screen. This will allow you to see the attorneys and the witnesses at the same time, which is important. So y'all should have been in speaker view, and I guess now you'll be in gallery view. So I'll give everybody a second to do that. And Ms. O'Connell, do you have the first witness?
Yes, Your Honor, the state calls Detective Blake Booth to the stand.
Okay. Detective Booth. And my understanding is all these witnesses have been sworn in prior to, so Detective Booth, you were still under the same oath that you took. Proceed.
Please introduce yourself to the members of the jury.
Hello, my name is Blake Booth.
What do you do for a living, Ms. Booth?
I am a homicide detective with the Skelton Police Department.
How long have you been with the police department?
I've been with them a little over 23 years now.
How long have you been a detective?
At the time of this investigation, I had been a detective for a total of 8 years, with 3 years in the homicide unit.
How many homicide investigations have you conducted while on that unit?
This was my 12th investigation.
What was your role in the investigation of this case?
I was the lead detective assigned to investigate the death of Nathan Ray.
How did you first become involved?
I received a call around 9 p.m. on October 19th of 2018 from one of our officers at a DUI checkpoint. The officer had apprehended a suspect in a missing persons case.
Who was reported missing?
Nathan Ray, a 6-year-old child.
And who was the suspect?
Timothy Ray, Nathan's father, the defendant.
So what did you do when you first arrived on scene at that DUI checkpoint that evening?
When I arrived, I saw the defendant sitting on the curb with his car pulled over to the side of the road as well. At that point, that's when I went over to Officer Wentz, who had called in to report the homicide.
What did you do after your interaction with Officer Wentz?
I focused my attention on the defendant and started the process of getting him transported to the station in order to be interviewed.
Did you ask the defendant any questions at that time?
Yes, I did. I asked him if he understood that we would have to take him to the station in order to ask him a few questions about his son.
What did he say?
He said that he understood and was willing to tell us everything.
Detective Booth, did you conduct any other investigations while you were on the scene?
Yes, I went to look at the defendant's car before it was taken to the police impound.
What did you see?
I was able to see a shovel covered in dirt and a red-like substance that appeared to be blood, 2 bottles of bleach, and a large trash bag.
Were those items ever collected?
Yes, we received a warrant to conduct a full search of the vehicle, and then I photographed the car before collecting each individual item.
Would you recognize those photos if I were to show you them today?
I would.
Calling court counsel's and witnesses' attention to what's been pre-marked as exhibits 23 and 26, found on pages 100 and 103 of the case file. Detective Booth, do you have these exhibits in front of you?
I do.
Do you recognize them?
Yes.
How do you recognize them?
These are the photos I took before searching the defendant's car on October 20th of 2018.
Are they a fair and accurate depiction of the defendant's car as it appeared back at that DUI checkpoint?
They are.
Your Honor, the state offers into evidence what's been pre-marked as exhibits 23 and 26, as states exhibits 23 and 26.
Mr. Ephraim, you have any objection?
No, not at this time, Your Honor.
Okay, then you said 23 and 26.
Yes, Your Honor.
All right, those will both be admitted. You can use and publish them however you wish.
Permission to publish to the jury at this time?
You may.
All right, Detective Booth, do you see Exhibit 23 on your screen?
Yes, I do.
Can you tell the members of the jury what we're looking at in this photo?
This is a photo showing all of the items that were recovered in the back seat of the defendant's car, including the bleach, trash bags, and shovel.
All right, now let's move on to Exhibit 26. What is this a photo of?
This is a close-up photo that shows the head of the shovel covered in dirt and what appeared to be blood-like substance.
Thank you, Detective Booth.
Correction, Your Honor, this is mischaracterization.
Your objection is mischaracterization of the evidence.
Yes, Your Honor.
Is that to, I guess let's move outside the presence of the jury. Mr. Ephraim, are you talking about, I guess her saying that's blood on the shovel?
Yes, Your Honor.
Okay, what's your response to that?
Your Honor, Detective Booth never said that it was blood. She said she saw a red-like substance that appeared to be blood. She's merely testifying as for her observations, and that's not a mischaracterization of this evidence.
And I think I heard that too. So Mr. Ephraim, what is your objection?
I did not hear her say at the time, and I thought that this was just simply stating that there was blood on the shovel. I did not hear the at the time portion.
And that's fine. You got a client, you got to make sure that you make all your objections. So I don't fault you for that, but I will overrule the objection and we're back in the presence of the jury.
All right, Detective Booth, now let's shift our focus to your interview with the defendant on October 20th of 2018. What was the first thing you did during this interview?
I went over the waiver of rights form with the defendant to make sure he understood what he was signing.
What is a waiver?
It's exactly like what you would probably hear about on TV. We give the defendant their Miranda rights to make sure that they understand the rights that they have and that they wish to waive those rights in order to give a statement.
Did the defendant sign this waiver?
Yes, and he also said that he understood it and was agreeing to waive his rights at that time.
So what was the first thing you asked the defendant after he signed this waiver?
I asked him whether he knew why he was at the station.
What did he say?
He said that he was there to tell us what happened to his son, Nathan.
Would you recognize a photo of Nathan if I were to show you one today?
I would.
Calling court counsel's and witnesses' attention to what's been pre-marked as Exhibit 29, found on page 106 of the case file. Detective Booth, do you have this exhibit in front of you?
I do.
Do you recognize it?
Yes, I do.
How do you recognize it?
This is a photo of Nathan that was provided to us by his mother on October 18th of 2018.
Is this photograph a fair and accurate depiction of what Nathan Ray looked like in October of 2018?
It is.
Your Honor, at this time, the state offers into evidence what's been pre-marked as Exhibit 29, as states Exhibit 29.
Any objection?
Yes, Your Honor. Permission to approach.
You may.
Your Honor, this photo is of living Nathan smiling and is prejudicial, more prejudicial than probative in regards to the trier of facts need for it.
Okay, Ms. O'Connell, what's your what's the probative value of the photo?
Your Honor, part of the state's burden today is proving first-degree murder, and part of that includes proving who the victim was. This is simply a photo of Nathan Ray. This is not a photo of his dead body. This is just to help the jury understand who Nathan was. We're going to be talking about him for the next few hours, and I think it's important for the jury to understand who Nathan was.
Your Honor,
response to that?
if I may respond,
Sure.
It's not being contested that Mr. Ray was, that Nathan Ray was the one murdered, or that Mr. Ray was the one that murdered him. These are facts that have been spoken to on my open and will be continually addressed as essentially stipulated facts. And this photo, therefore, is only prejudicial.
Okay. I guess, Ms. O'Connell, Mr. Ephraim has said that he is stipulating to the fact that Nathan Ray was a living person and now is no longer living. Are you willing to accept that stipulation, or would you like to offer the photograph and use your evidence as you were going to use it?
We're just simply using this to let the jury visualize and see who this victim was. That, you know, we're not going to go into details that he's smiling. We're just simply letting them see this photo, and we're only going to put it up for a couple questions, Your Honor, and then take it down.
And I tend to agree, Mr. Ephraim. I understand that y'all are stipulating. However, Ms. O'Connell doesn't have to accept that stipulation. And if she wants to use the photograph to show that he was a living person, I'm going to allow her to do that. It's overruled and we'll be back in the presence of the jury.
Thank you for your time. Your Honor.
Thank you.
Is it admitted, Your Honor, permission to publish to the jury?
Yeah, it is admitted. Yes, State's Exhibit 29 is admitted. And
Thank you,
may
Your Honor.
publish.
Detective Booth, did the defendant tell you what happened to Nathan?
Yes, he described in detail what happened to Nathan.
Can you tell the members of the jury what the defendant described?
Yes, the defendant indicated that on the morning of October 17th of 2018, Nathan was at home eating breakfast before getting ready to go to school. And at that time, he had happened to spill his juice onto the defendant's laptop.
Where was this taking place?
At the defendant's home in Skelton, West Carolina.
All right, so did the defendant tell you what happened to Nathan once he spilled the juice?
The defendant said that he needed to punish Nathan for spilling that juice on the laptop.
Did he explain what he meant by punish him?
Yes, he said that he started to yell at Nathan, which is when Nathan ran into the bedroom.
Did the defendant tell you what happened at that point?
He said he went after Nathan, following him into Nathan's bedroom, told him to start doing jumping jacks, high knees, to run in place, and not to stop until he said so.
Do you know how long this went on for?
Not specifically. He just said that he needed to punish him more. And that's when the defendant went into his own bedroom and grabbed a belt out of his closet.
Did he tell you what he did with that belt?
He went back to Nathan's bedroom, started hitting Nathan with it, but that made Nathan cry and scream even more.
What happened when Nathan cried and screamed even more?
The defendant told Nathan to shut up. When Nathan wouldn't, that's when he said he put the belt around Nathan's neck and he pulled until Nathan stopped screaming and eventually stopped moving.
Did the defendant tell you what he did with Nathan's body?
Yes, he put Nathan's body in his car and proceeded to drive for a few days before eventually burying him in the Brandywine State Park.
Were you ever able to recover the body of Nathan Ray?
Yes, after the interview with the defendant, I gathered a search team to conduct a search of the park. It only took about an hour until we were able to find his body.
Would you recognize a photo of that scene if I were to show you it today?
Yes, I would.
Calling court counsel's and witnesses' attention to what's been pre-marked as Exhibit 19, found on page 96 of the case file. Detective Booth, do you have this exhibit in front of you?
I do.
Do you recognize it?
Yes, I do.
How do you recognize it?
This is a photo that my forensics team took at the park that day when we conducted the search and were able to find Nathan Ray.
Is it a fair and accurate depiction of that search as it appeared on the day that you conducted that investigation?
Yes.
Your Honor, at this time, the state offers into evidence what's been pre-marked as Exhibit 19, as states Exhibit 19.
Okay, Mr. Ephraim, any objection?
Yes, Your Honor, permission to approach.
You may.
Your Honor, this again is more prejudicial than probative. Mr. Ray murdered Nathan. We've heard the detective testify that he found the body in the park, and this is more seeing the photo is more prejudicial than probative since the information is already in the record, and on top of that, it becomes cumulative.
Okay, and Ms. O'Connell, what's your response to that?
Yes, Your Honor. Part of the state's burden today, as the defense has raised the affirmative defense of insanity, we have to rebut the presumption that the defendant did not know the difference between right and wrong. This evidence goes directly to prove that. This defendant attempted to cover up the murder by burying the body and trying to, get rid of the body by covering it in dirt. And that's what this evidence is going to prove. Additionally, Your Honor, we were only attempting to enter one piece of this evidence. We had multiple photos provided, but as I would agree with opposing counsel that more than one photo would be cumulative. However, it's important for this jury to see that scene.
Respond to Mr. Ephraim's argument that the photograph is cumulative of the testimony of Detective Booth. So she's already testified she found the body there.
Yes, Your Honor, she's testified that she found the body there. However, it's important for the jury to see that the victim was wrapped in a trash bag covered in dirt and to see the full context of that scene. Just by Detective Booth saying where this happened and that she found him at this park, the jury should be able to visualize this scene as it goes directly to the state of mind and whether he was able to determine right from wrong during that period of time around the murder.
Ms. O'Connell, I tend to agree with you, Mr. Ephraim. Your objection is well noted, but I'm going to overrule it as to that photo. If she attempts to enter any more photos of the same thing, then I will re-entertain your cumulative objection.
All right, I just ask that Your Honor keeps in mind that they must take the photo down after the line of questioning regarding the body.
Yes, sir. And if you feel like the relevance of having the photo up and published has passed its time, then go ahead and make an objection or ask them to do that, and I will order them to do that if I think it's appropriate.
Thank you. Nothing further.
Overruled. The exhibit is admitted. That's exhibit number 19, and you may publish to the jury whenever is relevant. Thank you.
Yes, Your Honor. Can my co-counsel publish to the jury, please? Detective Booth, what are we looking at in Exhibit 19?
This is a photo of the forensics team search the day that we found Nathan Ray. He is in a trash bag on a path of the Brandywine State Park.
Was this trash bag consistent with the trash bags you found in the defendant's car on the night of the DUI checkpoint?
Yes.
Thank you, Detective Booth. Let's move on. Was an autopsy ever performed on Nathan's body?
Yes, it was. I was able to review a copy of the medical examiner's report after the autopsy had been conducted.
What was Nathan Ray's cause of death?
Asphyxiation.
And the manner of death?
Homicide.
Detective Booth, did you conduct any other investigations, any other searches during your investigation?
Yes, I conducted a search of the defendant's house as well as a search of the defendant's cell phone.
All right, well, let's focus first on the search of the defendant's phone. What did you find on the defendant's phone?
I found 3 interesting internet searches.
Permission to approach.
There's an objection?
Yes, Your Honor.
Okay. Yes, you may approach.
Your Honor, the phone search that they are referring to lacks foundations. We do not know that it was Mr. Ray's phone or that he made the searches within this line of questioning, and they're assuming facts, not in evidence.
Your Honor, if I may be heard.
Yes, you may. And I'm assuming that, well, first, Ms. O'Connell, let me ask you, are you planning on getting into the content of these searches?
Yes, Your Honor. However, the parties did stipulate prior to trial that this was the defendant's phone. I can refer the court to page 5, stipulation 9. If you would like me to read it, I can right now, Your Honor.
No, well, maybe for the jury, I have seen that stipulation.
Okay.
I guess, is Mr. Ephraim, are you arguing that it's not the defendant's phone?
No. I corrected myself mid-sentence. I apologize. That Mr. Ray was the one that did the searches on the phone.
Okay, so let's go ahead, and since we're outside the presence of the jury, Ms. O'Connell, let's go ahead and just take up the discussion. I know it might involve some questions a few questions down the line, but if you are going to offer these searches, I'm assuming under what rule are you going to offer the searches?
Well, I anticipated that opposing counsel would object under hearsay,
Sure.
and this was stipulated to prior to trial that this was the defendant's phone. So we would argue that this is an exception to hearsay under 801D2 as a statement made by a party opponent. However, to opposing counsel's argument that this wasn't made by the defendant, that's an authentication argument, and these searches are directly tied to the murder in which the defendant confessed. It's our argument today that the jury is free to decide who these searches were made by, and that goes to weight, not admissibility, Your Honor. These searches should be admissible, and the jury should be allowed to see these searches, and then they are free to decide whether they believe or not that the defendant is the one who ultimately made these searches.
Okay, and Mr. Ephraim, I have a question for you. I understand your argument is that there's nobody that will be able to say that the defendant himself made the searches, but would you agree that if the defendant himself did make the searches, that it would be an admission by a party opponent and an exception to the hearsay rule?
Yes, if it were, yes.
Okay, so as far as now address what opposing counsel is saying and the prosecutor is saying is that whether or not he was the person that made the searches, that would go to the weight the jury can give it, but not the admissibility of it. So
You wish me to comment on the admissibility under the hearsay exception?
Yes, please. So basically what she's saying is even if right now they have enough evidence to show that it was him that made the searches because it was on his phone, and any question as to whether or not he was actually in the phone would go to the weight of the evidence and not the admissibility of the evidence.
Your Honor, I just disagree. I think if they aren't able to lay the foundation that he was the one that was able to make the searches, or at least not that he made them, but that he was at least able to make them, if they're not even laying that foundation, then this does go to the admissibility.
Okay, and that objection is noted. I do consider that goes to the weight, not the admissibility. Mr. Ephraim, you are going to be free to cross-examine Detective Booth or any other witness about whether or not they have any evidence that it was actually the defendant pushing I guess, the letters to make those searches. But I will, thank you. And I will, so you will be allowed to use that under those terms that we laid out. Do you understand my ruling, Ms. O'Connell?
Yes, I do.
Okay, and so you don't have to admit them now, but whenever it comes that time.
Your Honor, I believe you muted yourself, but I'll just proceed with my direct examination and lay that foundation.
Thank you.
Detective Booth, let's go back to these phone searches. What did you find on the defendant's phone?
I was able to find 3 searches that the defendant made that were at least discovered on his phone.
What date were these searches conducted on?
October 18th of 2018, the day after the murder.
Calling court counsel's and witnesses' attention to what's been pre-marked as Exhibit 10, found on page 57 of the case file. Detective Booth, looking at Exhibit 10, do you recognize it?
Yes.
How do you recognize it?
These are the screenshots on the defendant's phone that we found once we searched the defendant's phone.
Are these screenshots a fair and accurate depiction of the searches you found on the defendant's phone during your analysis?
Yes.
Your Honor, at this time, the state offers into evidence what's been pre-marked as State's Exhibit 10.
And Mr. Ephraim, do you have any objection other than hearsay or foundation, which I've already ruled on?
No, we've discussed my objections and they're preserved. Thank you.
Okay, then it will be admitted.
Permission to publish to the jury, Your Honor.
You may.
All right, Detective Booth, let's take these searches one by one. Can you tell the members of the jury what the first search you found was?
Countries that don't extradite for murder charges.
And the second?
How to get rid of a body.
What was the final search on the defendant's phone?
Will bleach destroy a body?
Last final question, Detective Booth, why were these searches relevant to your investigation?
As you saw earlier, we actually found bleach in the defendant's car.
Thank you, Detective Booth. A moment to confer, Your Honor. I have no further questions, Your Honor.
Okay. All right. Before we we're about to start cross, and for the benefit of the judges, like I said, I wasn't there in the judges meeting, but both sides have 55 minutes, and there will be a timekeeping. I will be asking for time, and also for the timekeepers, I'll be asking for time at the halftime, so that both sides understand how much time they have. And I just to let the judges know, 55 minutes is not a whole lot of time. So that may be why some of the questions might not be being asked that you would prefer. But with that, I will allow Mr. Ephraim to conduct his cross-examination.
Thank you for being here, Officer Booth. Do I have it right that you went to the academy 23 years ago?
Yes.
And you have had specific training in recognizing mental health distress or some type of mental disorder at some point?
Yes, about 23 years ago.
But you don't remember anything from that training?
No, not the specifics.
But you have since then gone to detective school or investigative school?
Yes, it was all a part of my training.
And you've now worked, you said 12 cases as investigator?
Yes, at the time of this investigation, it was my 12th investigation.
And so do I have it right that Nathan's death makes this the 4th investigation that you've been the lead investigator on?
Yes.
Thank you, Officer Booth. I'd like to move forward to your interactions with Officer Wentz that night that you first saw Mr. Ray detained on the curb. You said you spoke with Officer Wentz as a routine part of the investigation?
Yes, he's the one who called it in.
And is this standard practice to speak with the officer on site?
I would believe so.
Okay. And Officer Wentz told you about his observations of Mr. Ray?
He did.
That he had a strong body odor?
Yes.
That he looked disheveled?
Yes.
That he radioed in that Mr. Ray was acting crazy?
Objection, Your Honor. Hearsay and improper opinion. May we approach?
You may. Ms. O'Connell, is this what you dealt with in the motion in limine?
It is, Your Honor, to let officer, well, now opposing counsel is cross-examining Officer Booth on Officer Wentz's statements, and to just backdoor these statements in through Detective Booth and the statements made by Officer Wentz at that to allow that into the hearing of the jury is an improper opinion.
Okay. So Mr. Ephraim, I think that it's both it's kind of a double hearsay and speculation, because the hearsay that she's relying on, Ms. O'Connell's claiming is speculation on the part of Officer Wentz.
Officer, I was simply asking Officer Booth to let us know what Officer Wentz radioed in when he called in that officer, or that he had detained Mr. Ray, which is an observation that is a present sense impression he made, and it's a recorded recollection as it was part of his radio and what brought Officer Booth out to the checkpoint. And as for the other part of the hearsay, this is not offered for the truth of the matter asserted. It is offered so that the trier of fact may understand Detective Booth's understanding in his investigation and like the knowledge that he had at that point in his investigation prior to the interview with Mr. Ray.
Okay, so like an information acted on. This is the
Yeah.
reason that Detective Booth, this is the information he had when he went there. I understand that. So Ms. O'Connell, can you respond to that?
Yes, Your Honor, even if opposing counsel is able to get over the hearsay objection or my objection to hearsay on these statements are still an improper opinion. Officer Wentz is not qualified to make a determination that the defendant was crazy. Yes, we are agreeing that he did a 40-hour training program on crisis intervention training. However, that does not qualify him as an expert in forensic psychiatry or any field to give an ultimate determination of the defendant's mental health. And that would be an improper opinion.
I understand that. And Ms. Ephraim, I'm going to give you a chance to respond. But Ms. O'Connell, could you please respond to the, Mr. Ephraim said present sense impression as an exception to the hearsay rule. I know that you basically said, well, even if he could get over the hearsay, but do you believe that he's gotten over the hearsay and you want to move to speculation, or do you have a response to present sense impression?
Your Honor, I believe that the statements made by Officer Wentz to Detective Booth, if I'm understanding opposing counsel's statements, it's that Officer Wentz told Officer Booth that he radioed in. However, that would be looking back on the statements he made to whoever he called it into. He didn't make those statements to Detective Booth, and that wouldn't qualify as a present sense impression, Your Honor.
I tend to agree with that. Mr. Ephraim, you have a response?
Your Honor, I was simply ready to respond to the improper lay opinion.
The speculation?
Yes.
Okay. I would be inclined to overrule the hearsay on information acted on if you're not using it for the truth of the matter asserted. However, I would like a response now to the speculation on Wentz's part as far as the word crazy. I think any other observations are fine, but crazy is what I think what Ms. O'Connell is taking objection to.
Your Honor, I understand your hesitancy. However, Officer Wentz was simply making a lay opinion that many people can make. He wasn't using crazy in the clinical term, nor would he, as he is not qualified as an expert witness to discuss clinical terms. This is simply the lay opinion version of the word. It is the word he used, and so I can't change that. It is simply his impression at the time.
All right.
May I be heard on those grounds, Your Honor?
You may.
I would then raise a 403 objection, as the jury would then overvalue and mislead the jury into thinking that Officer Wentz is qualified to even deem him as crazy. That is not a lay opinion. That requires years of training and experience to make a determination as to someone if they are crazy or not, and to allow opposing counsel to cross-examine Detective Booth on that and for the jury to hear that would be inappropriate, Your Honor. That's what the experts are here for today, and I don't believe it's proper for Officer Wentz's statements to come in through Detective Booth in that manner.
Your Honor, if you'd like to offer a limiting instruction along with this line of questioning, I'm perfectly okay with that.
Well, I think what I'm going to do is I am going to overrule the objection. I will allow it for the purposes of information acted on for Detective Booth. This is why Detective Booth got involved in what was going on. I will give a limiting instruction, however, that it's not to be used for the truth of the matter asserted, so that these statements aren't necessarily true. And then Ms. O'Connell, I will expect that when Wentz comes to the stand and you or your partner cross-examines Wentz, that it will be brought up that the way that he's using crazy is not in the clinical sense. If he or she does not agree to that, then I will probably instruct the jury that they are not an expert under the court at that point.
Yes, Your Honor.
Okay. So I will allow it in, and you may continue.
Officer Booth, that night, Officer Wentz suggested Mr. Ray required medical assistance. Do I have that right?
Yes.
But you followed this up by asking if he had any signs of physical abuse or substance abuse?
I don't recall, but I do know that at that time he had expected medical treatment, but didn't even ask for it.
And Officer Wentz, when you asked him this, he didn't report any sign of substance abuse or physical injury to you?
No.
Officer Booth, thank you. You thought, we're going to move ahead now to your interactions with Mr. Ray. Did you interview Mr. Ray that night?
I had spoken to him, but it wasn't a typical investigation. No.
But you later brought him in for interrogation.
I transported him. Yes.
Yes. And during that interview back at the station, Mr. Ray understood what was happening?
Yes, at the station, he did say that he understood. He had signed the waiver to give a statement, which you would need to understand.
You can't really explain why, though?
No.
And have you had any medical training in recognizing, or any high-level medical training in recognizing someone's mental fitness?
Objection, Your Honor, asked and answered. Detective Booth's already testified that she hasn't.
I'll overrule it.
Mhm.
I'll overrule it.
So you have not had any high-level medical training with determining someone's mental fitness?
No, just the training that you had mentioned earlier about 23 years ago.
So nothing the defendant said during this interview was odd?
I did not believe so. No.
Did Mr. Ray ask if you were from the CIA at any point?
Yes.
Did Mr. Ray ask if you were from or with the CIA when you handed him the waiver of rights form?
Yes.
You had to remind Mr. Ray of your name?
Yes, but he eventually, he displayed that he knew my name by the end of the investigation.
You also had to remind him that you were part of the Skelton Police Department?
Yes.
And in your interview, he said she tricked him?
Objection, Your Honor, hearsay.
What's your response to hearsay?
Your Honor, this is not offered for the truth of the matter asserted. This is the defendant's then existing mental state, and these statements speak to that.
And the statement is, we're outside the presence of the jury. What is the statement?
She tricked him to spill the juice?
She tricked him to spill the juice. So Jessica Ray tricked Nathan into spilling the juice. Okay. Respond to it's not being used for the truth, but to mental state of the defendant.
Yes, I would say, Your Honor, that opposing counsel kind of contradicted themselves. They said they weren't using it for the truth, but then gave a hearsay exception. I would say that at that point, it is not his state of mind at the time, because kind of looking back saying that Jessica Ray tricked him, that's not then existing state of mind. He's referring back to previous times and what he knew before this event had happened.
Okay, respond to that as far as looking back. So it's not a then existing mental state. It's I guess a memory or something that had happened in the past.
Yes, sorry if I was unclear. This is a statement that was made by a party opponent, and I'm sorry, the question was asked by a party opponent, and the statement refers back to their mental state during the time that the question was referencing from the party opponent during the interview. Okay,
I will. I'm going to allow it to go to the defendant's mental state as far as. I understand that he's talking about something in the past, but I will allow it to go to his mental state at the time of the interview. The things that he is saying is not to be used for the truth. Ms. O'Connell, I will give an instruction that these statements are not to be used for the truth of the matter asserted.
Yes, Your Honor.
And you may proceed. And we're back in the presence of the jury.
Officer Booth, during your interview with Mr. Ray, he said they told me that she tricked him. Is that right?
Yes.
Mr. Ray said he put a belt around Nathan's neck because Nathan had to understand. Do I have that right?
Yes.
Mr. Ray said they told him to make Nathan understand.
I believe so.
Officer Booth, towards the end of your interview, did you call Mr. Ray a piece of shit?
Objection, Your Honor, relevance and hearsay.
All right. What is the relevance?
This speaks to the witness's bias. And
all right.
Bias is always relevant.
Overruled the relevance. What is the hearsay response?
The hearsay response to the fact that Mr. Ray was called a piece of shit is a party opponent, sir. I apologize.
All right, what is your response to that, Ms. O'Connell?
Your Honor, Detective Booth is not our party opponent. The state is prosecuting Mr. Booth. We don't have a party opponent, Your Honor. We don't have a party representative, I should say. Sorry, and my apologies.
His bias sure seems like he might be.
So noted, but I do agree with Ms. O'Connell that I wouldn't call it a party opponent. Is there any other hearsay exception that the statement will fall under?
Yes, Your Honor. This could also fall under a present sense impression, because this is Officer Booth's present sense impression of Mr. Ray during the interview.
So your argument is that, and excuse my language, but that Detective Booth perceived him as a piece of shit and said it when she perceived that?
Yes, this was his perception.
May I be heard on those grounds, Your Honor?
You may.
When we look to the rules under 803.1, it says a statement describing or explaining an event or condition. The statement calling Mr. Ray a piece of shit is not describing any event or condition, and therefore it doesn't qualify under 803.1.
I tend to agree. I'm going to sustain the objection.
Okay, Your Honor. Officer Booth, nothing about this interview was odd to you?
No.
Officer Booth, you could have requested the interview be preserved for evidence via video. Is that right?
Yes.
And you were the one that decided not to preserve the video for evidence and
No,
instead opted for a transcript.
Correct.
No further questions, Your Honor.
Okay, Ms. O'Connell, is there any redirect?
Briefly, Your Honor. Detective Booth, opposing counsel just asked you about your interview with the defendant and him referencing you as the CIA. At any point during that interview, did the defendant ever refer to you by name?
Yes, he did.
When did he do that?
Shortly after confessing to the murder.
And finally, opposing counsel asked you about the transcript of the interview with the defendant. Can you explain why you didn't keep a copy of the audio or video?
The defendant had confessed to the murder. It was very clear that this was a simple case. I was able to receive a confession from the defendant. It didn't need to come with an audio recording.
Did you intentionally go and delete this recording?
No, the videos are set up by policy to automatically delete, and it is not necessarily required to preserve that.
Thank you, Detective Booth. I have no further questions, Your Honor.
Okay, I will invite and under the local rules, there is no recross examination. So each examination will end with a redirect if the advocate chooses to make one. I will invite the prosecutor to call their next witness.
Your Honor, we'd like to call Dr. Mac LaGreca.
Okie doke. Dr. LaGreca, are you present? Dr. LaGreca.
Can you guys hear me?
Yes, we can.
Okay.
And Dr. LaGreca, you have been previously sworn and you're under the same oath that you were sworn to previously, and I will allow the prosecution to start their direct examination.
Can you please introduce yourself to the jury?
Hello, my name is Dr. Matt LaGreca.
What do you do for a living, Dr. LaGreca?
I'm a forensic psychiatrist as well as a professor at the West Carolina School of Medicine.
What work do you do as a forensic psychiatrist?
My work focuses on the relationship between psychiatry and the legal system. I work with a diverse population of patients to help diagnose and treat a wide variety of mental illnesses and disorder that they may suffer from.
And do you work directly with these patients?
I do. I devote 1 day a week to treating patients at the Jamie Spear Hospital in West Carolina.
Could you tell the jury more about your work experience in the field?
I've owned my own private practice for over 20 years, where I work directly with the patients in discerning disorders such as schizophrenia.
Do you still operate this private practice?
No, I've sold my practice and moved into full-time academia, serving as both a program director of the West Carolina School of Medicine Forensic Psychiatry Fellowship Program and as a professor.
What are your responsibilities as a director?
For my director role, I supervise the forensic psychiatry clinical rotations in the program.
And what are your responsibilities as a professor?
As a professor, I teach courses on mental health law, the law and the legal system, and introduction to forensic research.
Dr. Greco, what is your educational background related to this field?
I earned my bachelor degree in chemistry from the University of Delaware in 1985, and then I received my MD degree from the Perelman School of Medicine at the University of Pennsylvania in 1989.
And as part of this educational training, did you complete any residency training?
Yes, I completed my general psychiatric residency at the David Gaffman School of Medicine at the University of California, Los Angeles. That was in 1993. And then I returned to University of Pennsylvania, where I completed my forensic psychiatry fellowship.
Are you board certified, Dr. Greco?
Yes, I'm board certified in forensic psychiatry by the American Board of Psychiatry and Neurology.
Are you licensed in the field of forensic psychiatry?
Yes, I'm a licensed psychiatrist in 3 states, New Jersey, Pennsylvania, and here in West Carolina.
Have you been published in the field of forensic psychiatry?
Not yet. I've spent so much of my time actually treating patients and only recently moved into full-time academia, but I'm currently working on a paper discussing the concept of malingering in cases of capital punishment.
Dr. Greco, have you testified in trial before?
Yes, I've been an expert witness in 7 prior cases, 5 of which were related to mental health disorder. That includes schizophrenia, bipolar disorder, PTSD, and generalized anxiety disorder.
Are you normally retained by one side over the other?
I have testified for both the defense and the prosecution. I testify, however, the facts lead me to, regardless of the side.
And how much do you charge for this work?
I charge $500 an hour to review materials, and then if I'm called to testify, I charge a flat fee of $1,750 per day.
Let's talk about this case. Why are you here today?
I was asked by the state of West Carolina to form an opinion on the status of Mr. Timothy Ray's mental health on October 17, 2018.
And were you able to reach an opinion regarding the defendant's mental health on that date?
Yes, I was.
What is your opinion based on?
My opinion is based on a combination of information and knowledge acquired from my years of education, as well as clinical practice in the field, interaction with other psychiatrists, as well as the review of all materials relevant to this case.
And what were those specific materials that reviewed in furtherance of this case?
I thoroughly review all materials that are listed on the joint exhibit list, including the transcript of Detective Booth's interview with the defendant's medical records, and as well as the report of Dr. Shane Riley.
And do you reach your opinions in this case to a reasonable degree of medical certainty?
Yes, I did.
What methods did you rely on to come to your conclusion?
I relied on a DSM-5, which is a manual designed to assist forensic psychiatrists in diagnosing various mental illnesses. This was applicable for my evaluation of whether the defendant was suffering from schizophrenia.
And is this DSM-5, is it widely accepted in the field of forensic psychiatry?
Yes, it is.
And did you reliably apply the DSM-5 to the facts of this case to reach your conclusion?
Yes, I did.
Dr. Greco, were you able to interview the defendant in person?
No, I wasn't.
Did this affect your opinion?
No, it didn't.
Your Honor, at this time, the state wishes to tender Dr. Greco as an expert in the field of forensic psychiatry.
Mr. Allison, do you have any objection?
No, Your Honor, we have no objections.
All right, he will be accepted as an expert in forensic psychiatry, and you may proceed, Mr. Markle.
Dr. Greco, what is your opinion in this case?
My opinion is that Mr. Timothy Ray did not suffer from any severe mental disorder on October 17, 2018, including schizophrenia.
Objection, Your Honor. This calls to the ultimate issue.
Okay, and what are you basing that on?
May we approach, Your Honor?
You may.
Your Honor, the witness's statement directly references one of the elements needed to determine whether or not Mr. Ray was insane at the time. He specifically mentioned whether or not the defendant was suffering from any severe mental illness.
Okay, do you have a response, Mr. Marcus?
Yes, Your Honor. The expert witness is allowed to testify as it's not an ultimate issue in this case. The ultimate issue is whether he was understood right from wrong. What we're eliciting and what we expect him to say is that the defendant was suffering from schizophrenia. This is a fact and circumstance regarding the case, and the jury must be able to know this information from our expert witness and able to come to a conclusion for this case.
And Mr. Allison, I'm going to allow that. If you believe that they go to the ultimate issue of whether or not your client knew right from wrong, I will entertain another objection. I do find that I don't know what he would testify to if we didn't allow him to testify to the schizophrenia. So I'm going to overrule the objection. I'm going to allow you to continue, Mr. Marcus.
I'm going to ask that question again, Dr. Greca. What is your opinion in this case?
My opinion is that Mr. Timothy Ray did not suffer from any severe mental disorder on October 17, 2018, including schizophrenia.
And before we move any further, can you explain to the members of the jury what schizophrenia is?
Schizophrenia is a rare brain disorder that less than 1% of the world suffers from, and it typically causes visual and auditory hallucinations.
How is someone diagnosed with schizophrenia?
So in order to formally diagnose schizophrenia, individual must have experienced at least two of the symptoms that are defined in the DSM-5 for schizophrenia for a period of more than a month.
And Dr. Greca, what are those symptoms?
In addition to the hallucination, as I previously mentioned, other symptoms include delusions, disorganized speech, disorganized behavior, and finally, a separate group of symptoms called negative symptoms.
What are negative symptoms?
These negative symptoms are symptoms that will prevent someone with schizophrenia from engaging in certain behaviors, basically making it really difficult to maintain a normal life.
And how do you apply that to this case here today?
So I use the defendant's background information and the medical history. I then connected with the DSM-5 standard factors that are used to assess the defendant's psychological condition, and then I assess whether he suffered from schizophrenia.
What did you learn about the defendant's background?
I first learned that Mr. Timothy Ray was primarily raised by his father, Mr. Abe Ray, as his mother neglected and abused him when he was a child. She was institutionalized for mental illnesses when Mr. Ray was 3 years old.
What mental illness did the defendant's mother suffer from?
It's not entirely clear. The only information that we have is that she suffered from severe mood swings.
And did he receive a college education?
He did. He graduated from Skelton University in 2008 at the top of his class. He earned a bachelor's degree in computer science.
Did this have any effect on your analysis of the defendant?
Well, you see, this was a very important part of my analysis because for someone with such severe schizophrenia, we would expect to see little to no educational background. And even if they were able to complete their education, they're usually unable to maintain employment after the graduation. Again, top of his class he was.
And was this defendant able to maintain employment?
Yes. From what I reviewed, he was described as a fantastic employee and held a job as the computer technician at Computerland for 7 years.
What did the defendant do before working at Computerland?
He enlisted in the military after graduating from college, but was discharged from basic training after a couple months.
Why was he discharged?
Not entirely sure. His commanding officer suspected that Mr. Ray was suffering from hallucination.
Objection, Your Honor. Hearsay.
Your response to hearsay?
Yes, Your Honor. An expert can rely on hearsay when it's
Hold on real quick, Mr. Marcus. I'm sorry. Let's move outside the presence of the jury.
Oh, sorry. Yes, Your Honor. May I approach?
Yeah, and just so I don't know exactly what the statement is. So what is the statement that you're going to try to elicit?
Yes, Your Honor. Why was he discharged from the military?
Okay, and what is the answer?
And Your Honor, under 705, expert can reasonably rely on inadmissible evidence if they are forming their opinion.
Okay, and so what is I guess what will be the witness's answer to why he was discharged?
If permitted to testify, Your Honor, we believe that he's going to say that they're not entirely sure, although his commanding officer observed he had trouble with sleeping, with hallucinations, suicidal thoughts, and depressive thoughts, Your Honor.
Okay, and Mr. Allison, you are objecting to hearsay on that. Mr. Marcus has responded that as an expert, he is allowed to rely on what may otherwise be an admissible hearsay to form his conclusion or opinion. What is your response to that?
Your Honor, while he is allowed to do that only if it's highly more probative than prejudicial, and I'm not sure why this would be more probative than prejudicial in this case. Further, if I am overruled on that objection, a proper foundation hasn't been laid as to how this testimony gets in.
Okay, meaning like you don't know who you heard that from or where you read it?
That is correct.
Okay, Mr. Marcus, as far as the probative value, what is the probative value of the statement that you're trying to elicit?
Yes, Your Honor. The probative value, we're sitting here in court determining whether he knew, understand right from wrong. With that, you have to understand whether this defendant suffered from schizophrenia, a severe mental illness at that time. The testimony that we are going to elicit, Your Honor, goes directly towards whether he was suffering and has suffered from a severe mental illness in the history of his life.
Okay. I do tend to agree with Mr. Allison. I'd like to hear from the witness where in the report that this is located, or where he read this, or where he found this out from. But if you do establish that predicate, I will rule that the probative value does substantially outweigh the prejudicial effect, and I will allow this expert to talk about, I guess, the reason for the discharge. So we're back in the presence of the jury. If you lay that predicate, then I will overrule the objection.
Dr. Greco, where did you read this from the valuation?
I read it from the case report.
Was that case report conducted by Major Riley?
Yes, I believe so.
Your Honor, may I continue with questioning on why he was discharged?
You may.
Why was he discharged?
Just hold on
Your Honor, if I may renew, my objection.
not entirely sure.
Excuse me, Dr. LaGreca, we have we have another objection. What is the objection, sir?
Your Honor, the entire case report is a very general document filled with lots of exhibits. Really referencing to the case report doesn't specifically tell me where he's getting the foundation for this testimony that he's about to get in.
I believe he said Dr. Riley's statement, your expert witnesses. I don't know if you heard that, but I believe he said he's got the discharge from Dr. Riley.
Your Honor, I did hear that, but Dr. Riley has multiple exhibits with his name on it. And I'm just confused as to which specific exhibit.
Your Honor, if I may. You
may.
I would like to instruct the court counsel's attention to page 71, paragraph 3.
Okay. And is that's where Dr. LaGreca is getting his, are you satisfied, Mr. Allison?
Yes, I am.
Okay, then I'll overrule the objection. I'll allow the witness to answer.
Dr. LaGreca, why was he discharged?
I'm not entirely sure. His commanding officers suspected that Mr. Ray was suffering from hallucination, depression, and suicidal ideation, but that was outright denied by Mr. Ray at the time.
Was a psychological evaluation conducted at the time that the defendant was discharged?
Yes, it was.
And who conducted that evaluation?
Major Shane Riley.
What were the results of this evaluation?
Major Riley concluded that the defendant did not suffer from any severe mental illness, and he discharged him a few days after diagnosing him with generalized anxiety disorder and prescribing Paxil, which is a common medication used to treat anxiety and depression.
Is general anxiety disorder common?
Yes, it is extremely common. About 1 in 5 Americans suffer from it.
Was this the only time that the defendant was evaluated by Major Riley?
No. Dr. Riley interviewed the defendants after he was arrested in this case.
When was that, Dr. Greca?
That was on September 9, 2018, almost a year after Mr. Ray was arrested.
Did you review Major Riley's findings of the defendant after he was arrested?
Yes, I did.
And did anything stand out to you in that report by Major Riley?
Yes, I was concerned about a few things.
What was the first thing that concerned you?
Well, my first concern was that there were numerous symptoms Mr. Ray reported to Dr. Riley that had never been reported to any medical professional before, or that had been observed by any of his friends or family at the time of the defendant's arrest.
What symptoms was he referring to?
Mr. Ray claimed that he had been hearing voices since he was a young child, that he has had intermittent visual hallucinations since 2016, and that he was experiencing paranoia and delusion and negative thoughts.
Did you find any evidence in the defendant's history to indicate the presence of these symptoms?
The only thing I was able to find was his paranoia.
Can you explain, doctor?
Well, the defendant's paranoia he had been experiencing in the months that leading up to the murder wasn't delusion within the meaning of schizophrenia, but rather he was paranoid that his wife was cheating on him, which turned out to be true.
What was the other thing you noted from Major Riley's report?
The final piece that stuck out to me was that Mr. Ray told Dr. Riley that before he went into the bathroom to kill Nathan, he took a moment to try to calm down, but he was unable to, and then decided to kill Nathan.
Did this affect your analysis of the defendant?
Well, that leads me to my conclusion in this case about the status of the defendant's mental health and whether he was malingering at any point during this investigation.
Doctor, what is malingering?
Malingering is something we, the forensic psychiatrists, are trained to identify. It's basically when a person is faking their symptoms.
How can you determine whether someone is malingering or not?
Well, the DSM-5 provides 4 specific factors to be considered when determining whether an individual is malingering.
Can you explain to the members of the jury what these factors are?
Sure. The first factor to be considered is the legal context of the clinical assessment. So basically, are we dealing with someone who has been arrested, or are we just, is that person just talking to the police officer?
And how did this factor apply to this case here today?
In this case, the defendant was being investigated by the police, and he was subsequently arrested for the murder of his son. So I found that this factor to be present.
What is the second factor?
The second factor we look to is whether are there any marked discrepancies between the individual's claimed psychiatric disorder and the objective findings, or what has been previously diagnosed and reported by the medical professionals.
How did this factor into your analysis?
I found marked discrepancies between the symptom described by Mr. Ray during his interview with Dr. Riley and symptoms, or really the lack of symptoms, documented in any of his medical records.
Can you explain more about these discrepancies?
So in the 2010 interview with Dr. Riley, Mr. Ray outright denied ever having hallucinations or any other symptoms associated with schizophrenia. But then after he was arrested, he claimed that he had been hearing voices since he was 10 years old.
Objection, Your Honor, hearsay.
Response to the hearsay.
Your Honor, just like before, under Rule 705, expert is allowed to, if they reasonably rely on something for their opinion, even though inadmissible, they are allowed in this case to rely on that hearsay.
And the statement being outside the presence of the jury, the statement is that he had been hearing voices since he was 10 years old. Is that
Yes.
what? Okay. Mr. Allison, what's your response to that?
Your Honor, this is hearsay within hearsay. Co-counsel is referring to a statement made by Mr. Ray, but that is referenced in Dr. Riley's report. So while one layer of the hearsay may be addressed, the other is not.
Mr. Marcus, how do you address the second layer of hearsay?
Your Honor, it would be admissible by party opponent.
All right, I agree. So as to the 705 argument by Mr. Marcus, Mr. Allison, how do you respond to that?
Your Honor, it's still unclear to me how this would be more significantly probative than prejudicial at this point.
All right, Mr. Marcus, how is it more probative than prejudicial?
Yes, Your Honor. The probative value of this is we're here to determine whether he was suffering from a severe mental illness. What you heard from Dr. Greca is that malingering is an individual can fake their symptoms. The jury is able to weigh this evidence, and I'm simply going through the factors. This is highly relevant in today's case, Your Honor.
All right, Mr. Allison, your objection is noted. I will overrule it. It's not to be offered for the truth of the matter asserted, but as far as Dr. LaGreca used it for his opinion. And we're back in the presence of the jury.
Dr. Greca, I'm going to ask that one more time. Can you explain more about these discrepancies?
Yeah, so in the 2010 interview with Dr. Riley, Mr. Ray outright denied ever having hallucinations or any other symptoms associated with schizophrenia. But then after he was arrested, he claimed that he had been hearing voices since he was 10 years old.
Can you explain the third malingering factor?
The third malingering factor we look for is whether the individual has failed to cooperate during the diagnostic evaluation or failed to comply with the therapy.
And did you find that factor to be present?
Yes, I noted that Mr. Ray was not cooperated with Dr. Riley throughout the interview.
What was the final factor?
Finally, we consider whether there is a presence or previous diagnosis of antisocial personality disorder.
Was this factor present?
No, this factor was easily eliminated because the defendant did not have any history or diagnosis of antisocial personality disorder.
So were you able to reach a conclusion regarding malingering in this case?
Yes, I concluded that the defendant manifested signs consistent with malingering during his interview with Dr. Riley.
Dr. Greca, I'd like to talk to you about your analysis of the defendant's mental condition. Was he ever diagnosed with schizophrenia prior to his arrest?
No, he was not.
Was there any documentation with the defendant where he ever reported experiencing symptoms associated with schizophrenia prior to his arrest?
No, other than the diagnosis of generalized anxiety disorder and depression, that he was never diagnosed with any schizoaffective disorder or schizophrenia by any mental health professional prior to arrest on the murder charges.
And what is your final conclusion in this case?
My final conclusion after reviewing all relevant information was that the defendant did not suffer from any severe mental disorder on October 17, 2018, when he committed the murder of his son, Nathan Ray.
Thank you, Dr. Greca. A moment to confer, Your Honor.
You may.
No further question at this time, Your Honor.
Okay, Mr. Allison, I'll invite you to cross-examine.
You're prepared to proceed. Dr. LaGreca, I'd like to talk to you about some of the psychiatric work that was done on this case. You did not conduct any interviews of anyone that knew Mr. Ray, correct?
That's correct.
Instead, you relied entirely upon the interviews and interpretations of those interviews that that Dr. Riley conducted.
Correct.
And that's how you formed your opinion in looking off of what Dr. Riley conducted.
Correct.
And although you didn't have access to the defendant, Mr. Ray, you could have conducted interviews on Dr. Riley's boss, or I'm sorry, on Mr. Ray's boss.
Yes.
You also could have conducted an interview on Mr. Ray's wife.
Yes.
And you also could have conducted an interview with Mr. Ray's father.
Yes.
And you're aware that Dr. Riley interpreted all of these interviews to mean that Mr. Ray didn't have had schizophrenia, correct?
Correct.
And after using all the same evidence and the same interpretations of the interviews that Dr. Riley completed, you came to a different conclusion than Dr. Riley.
That's correct.
Dr. LaGreca, I'd like to talk to you a little bit more about why you're here today. You've been hired as an expert witness before.
That's correct.
7 times?
7 times.
And 6 of those 7 times has been for the prosecution.
Correct.
And you're also being paid to be here today, correct?
That's correct.
You're being paid $500 per hour to review materials?
That's correct.
And you've reviewed materials for 25 hours leading up to this trial.
Yes.
And you're also being paid to give testimony today.
Yes.
$1,750 for your testimony today?
Correct.
And it's the prosecution that's paying you for your opinion today, correct?
Correct.
Okay. Dr. LaGreca, I'd like to move on to some of your work on malingering. You don't have any publications in the field of forensic psychiatry.
No, I'm currently working on it.
Which means that you're reliant on other people's research in order to form your opinions.
That is true, but my own, I'm also conducting my own studies at this point, and and I'm also relying on the early data from my own studies as well.
Sure, that's part of your practice, but when conducting and when citing to research, you can't cite to your own report yet, correct?
Correct.
And what you did cite to is that studies show that 19% of people when interviewed in a criminal context are malingering.
Correct.
Which means that study would then suggest that 81% of people aren't malingering in a criminal context.
Correct.
So statistically, it's far more likely that a person wouldn't be malingering.
It appears so.
So if we were to apply those statistics that you cited to Mr. Ray, it's statistically far more likely that Mr. Ray is telling the truth about his schizophrenia.
Statistically.
No further questions, Your Honor.
Any redirect, Mr. Marcus?
Yes, Your Honor.
All right, go ahead.
Now, counsel brought us up applying statistics, but what percent of people, Dr. LaGreca, are found to be suffering from schizophrenia?
Less than 1% of the world population.
Dr. LaGreca, why were you not allowed to interview the defendant?
because the defense team did not allow me to.
And did the fact that you weren't allowed to defend it make it so you cannot give an opinion in this case?
Well, I think I should be, just by reviewing the cases, I should still be able to form an opinion on this matter.
So it didn't affect the accuracy of your case.
That's correct. It didn't.
That's all, Your Honor.
Okay. Dr. LaGreca, you are excused. Thank you for your participation and cooperation.
Thank you.
We will, okay, we are, I guess I'll ask the state if, do you have any further witnesses?
Not this time, Your Honor.
Okay, does the state rest their case?
Yes, Your Honor, we do.
Okay, and I'm assuming the defense has a case to put on?
Yes, Your Honor, we do.
Okay, is there any motions to be made outside the presence of the jury?
No, Your Honor.
Okay, then what I'll do is everybody, let's take a 5-minute break so we can go to the bathroom, get a drink, do what you need to do to get ready for the next half. And my time right now is 2:47 Central, so that means that y'all are probably at 3:47 on the Eastern, I guess on the Eastern time zone. So why don't we come back at either 3:52 or 2:52 my time, all right?
Yes, Your Honor.
Okay. I guess could I see the timekeepers, please? That's Ms. McCormick. And who else is timekeeping?
That'd be Eric.
Okay. 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 I guess if somebody can communicate that time, I don't see Eric. Can you please give me a time check so that I know how much the Ms. McCormick, you're the prosecution team.
Yes,
Can you tell me how much the prosecution team has?
they would have about 24 minutes
Is that 24 minutes used?
left.
Oh, 24 minutes left. Okay. So they have used, I guess, 31 minutes. And for my defense team, do we have? Yes.
Yes, Your Honor. The defense has used 15 minutes, 36 seconds.
Has used how much?
Oh,
15 minutes, 36 seconds used.
and I think we have agreed on the time, both Eric and I. But if we could just take a moment to finalize those calculations, just to be sure for the record.
Sure. I'll give you that moment to do that.
Thank you. Sorry, Your Honor, math is not my strong suit, so I just need one moment.
That's okay. Take your time.
Your Honor, it does look like after I am recalculating that we would have closer to 26 minutes. I apologize, not 24.
Okay. Does the defense agree with that?
We'll confirm. We'll concede to that. Yes, that's good.
Okay. All right. So 26 minutes remaining, and then I guess 51 minus 15 is what, 41, 30, 37 or so, 36. Okay, y'all keep in time. I just wanted everybody to know where the time was at right now. And I will, if everybody's ready, I guess if I could just have an acknowledgement from the jurors. I just want to make sure all my jurors are back. I don't know if that just means y'all.
I'm back. This is juror list.
Okay. Juror Nielsen.
I'm back.
Okay, and Ms. Pearson.
I'm here.
Okay, perfect. So now that we have everybody here, we will begin. I'll invite the defense to call their first witness.
Your Honor, at this time, defense calls Officer Peyton Wentz.
Okie doke. Officer Wentz, you have been sworn, and Mr. Allison, you're free to question when ready.
Officer Wentz, could you please tell the jury what your occupation is?
Yes, I'm a police officer with the Skelton Police Department.
And what is your relationship to Mr. Ray's case?
I am the first officer to make contact with Timothy Ray after he murdered his son. I'm the officer that originally detained him.
Officer Wentz, could you please tell us what you were doing when you came into contact with Mr. Ray?
Of course, I was working at a DUI checkpoint that evening.
And when you saw Mr. Ray's vehicle approach, what did you do?
I asked him to roll his window down so that I could speak with him.
And after his window was rolled down,
Objection, Your Honor, hearsay.
The objection, well, all I heard was after the window was rolled down.
Sorry, Your Honor. May I approach?
You may.
Your Honor, sorry, I was muted. My objection was to the earlier statement, what he asked him to roll his window down, Your Honor.
Okay, so the objection is to hearsay that he asked him to roll the window down? Okay, response, Mr. Allison?
Your Honor, this is merely showing the course of the investigation. I'm not using the statement for anything other than that.
Okay, and as a command, I guess there's not really asserting a truth. He's just telling him to do something.
That's correct.
I'll overrule it on that basis. If you want an instruction, Mr. Marcus, I will, that it's not for the truth. All right, continue.
Officer Wentz, after the window was rolled down and you had a clear line of sight to Mr. Ray, did you make any initial observations?
I did. There was a strong smell of body odor radiating from the car. He looked very disheveled. His clothes were all stained up and dirty. It looked to me like he'd been living in his car for a couple of days.
Thank you.
Objection, Your Honor, speculation.
What's your response to speculation, Mr. Allison?
Your Honor, the officer is merely describing the course of his investigation based on observations that he made of the defendant at the time he was interacting with him.
I'll overrule.
Officer Wentz, what did you do after you made contact with Mr. Ray?
I asked him for his license and registration, pretty standard protocol.
And did he comply with your command?
Actually, not at first. He tried telling me that he left his wallet at home, but I could clearly see it in the front seat of his vehicle.
And did he eventually comply with your order?
He did. He eventually complied with the order after I insisted.
Okay. Officer Wentz, after you received the license and registration, what did you do?
I was going to walk that information back to the squad car so my partner could run that information through the system.
On your way back to the squad car, did you make any other observations?
Yes, as I was walking back to the car, I stopped at the defendant's back window. I shined my flashlight through the rear window, and I saw 2 bottles of bleach, a shovel, and some trash bags.
Now, Officer Wentz, after you gave your partner, Mr. Ray's information, what did you do next?
I walked back to the vehicle where Timothy Ray was sitting.
And what happened after you got back to Mr. Ray's vehicle?
He started acting kind of strange. He was talking about how he could hear CIA sirens, and he was asking me if I was in the CIA.
And what did you, so after he's asking you about, or telling you that he's hearing these sirens, were there any sirens going on at that time?
No, not even our sirens were on at the time. There was no sort of siren going on.
And what did you do after being confronted with such strange behavior?
Well, I tried to calm him down. Once again, told him, hey, I work for the Skelton Police Department. I even pointed to my badge to try to clarify that. At that point, I asked him to step out of the vehicle.
Officer Wentz, I'd like to take a pause right there and talk a little bit more about your education and training. Officer Wentz, how long have you been a police officer with the Skelton Police Department?
I have been with the Skelton PD for 2 years now.
And what is your highest level of education completed?
I have a bachelor's degree in criminology.
Did you complete any training specific to being a police officer?
Yes, of course. I went to the police academy.
And during your time at the police academy, did you take any specific training relating to how you interact with people who have mental health issues?
Yes, I did.
I took relevance.
Okay, the objection is to relevance. Mr. Allison, please respond.
Your Honor, this provides context to the observations that Officer Wentz made, and as well the argument that we're making with our case is putting Mr. Ray's mental condition directly at stake. And if Officer Wentz has any training on how to deal with people with mental illness, that's directly relevant.
Okay, doke. I'm going to overrule on relevant.
Officer Wentz, I'll repeat my question for you. Do you have any training while you're at the police academy specific to mental illnesses and how you interact with that in the public?
Yes, I completed a 40-hour course we refer to as crisis intervention training, CIT for short.
And what type of things did you learn in crisis intervention training?
We learned to recognize and react to individuals that were dealing with mental issues.
Okay. And Officer Wentz, did this crisis intervention training kick in at all during your interactions with Mr. Ray?
Yes, to me, the guy really didn't seem right in the head from the beginning of our
Objection, Your
interaction.
Honor,
to the-
improper opinion.
Okay, the objection was improper opinion. Mr. Allison, I think that, Mr. Marks, if I can confirm, it was Officer Wentz's statement that he didn't seem right in the head.
Yes, Your Honor.
Okay, Mr. Allison, please respond.
Your Honor, after the observations that Officer Wentz made, he's just making a determination on the type of individual that he's dealing with. He's not using this in any sort of clinical setting, just merely as a layperson, to describe the person that he's interacting with.
Okay. Yeah, Mr. Marcus, I'm going to overrule that objection. However, I remember talking to Ms. O'Connell about this issue. I will let you cross-examine on the fact that his observations are not from the perspective of an expert or a psychiatrist or somebody with that kind of, I guess, that kind of background. And so I will let you confirm or do that on cross, but I will overrule it this time. You can continue, Mr. Allison.
Thank you. Officer Wentz, I'd like to move back into your interactions with the client or with Mr. Ray. After, when you asked Mr. Ray to exit his vehicle, did he comply with your order?
No, once again, he refused to comply. Initially, he kept asking for my CIA credentials, like I didn't just explain to him who I was and that I don't work for the CIA. I had to explain who I was again, and then he finally got out of the car.
And when he got out of the car, what observations did you make of Mr. Ray?
Well, his demeanor completely changed. It was sort of like he went into some sort of zombie-like trance. He went from being panicked and frantic to zombie-like.
And Officer Wentz, did he ever leave the zombie-like trance?
Eventually, he sort of snapped back to reality. He told me that he was just trying to get his son in shape and make him do exercises and admit what he broke. Then he wanted his son to do jumping jacks.
Officer Wentz, after talking
Objection,
about...
Your Honor, hearsay.
Okay, and I guess, was it to the last answer that you just heard? Okay.
Yes, Your Honor.
Response to hearsay?
Your Honor, this is simply just going through the course of his investigation, the observations that he made. I'm using it for that purpose.
I think specifically he's, and we'll go outside the presence of the jury. I think specifically he's objecting to Officer Wentz testifying about what your client told him about what was going on during the time.
Your Honor, that would fall under a present sense impression, what the officer was perceiving and how that impacted his mental state at that time.
Okay. What about the statements from your client to the officer? Do you have a response to hearsay on those?
Your Honor, I would just stipulate that those are just observations that he's making in the course of his investigation.
All right. You have a response to that, Mr. Marcus?
Yes, Your Honor. They're not observations, even though they might be, they're still statements, Your Honor, and they're being brought in for the truth of the matter asserted. Again, is then existing mental state. He's relying on issues that have been shown to have occurred in the past, and therefore this isn't his then existing state of mind.
All right. I'll give you the last word, Mr. Allison.
Your Honor, again, I'm not using these to show that he wanted his son to do jumping jacks, just merely that he made the statement that he said that he was telling his son to do jumping jacks.
So you're not offering it for the truth of the matter asserted?
That's correct.
All right. And then I'll give you a response to that.
Yes, Your Honor. If I may, if they're not offering it for the truth of the matter asserted, then why is it relevant, Your Honor?
Right.
I don't believe that's a fact of consequence in today's matter.
Okay. I believe it is relevant to show the state of mind of the defendant at the time. And so I will allow it as not for the truth of the matter asserted. Those statements. Overruled.
Officer Wentz, after observing these statements, what did Mr. Ray, what actions was Mr. Ray taking?
Well, after he talked about needing his son to do jumping jacks, Mr. Ray started doing jumping jacks, and I had to order him to stop He refused to comply once more, so I drew my weapon on him.
And after you drew your weapon, what happened next?
He put his hands over his ears like a little kid that was trying to stop hearing something. Eventually, I was able to get his hands down and cuff him.
And what happened after you put handcuffs on him?
He just started rambling about his son.
And once he begins rambling and you have him detained, what action do you take next?
Well, that's when I radioed this into the station. My partner called me over to say that the information came back as belonging to a suspect in a missing persons report.
And Officer Wentz, did you request emergency medical presence?
No, not specifically.
What did you specifically report?
That he was acting crazy and that he was off his rocker.
Objection, Your Honor. Improper opinion.
Okay. Response to improper opinion?
Your Honor, again, our counsel has the opportunity to determine on cross the reason for his opinion. He's not offering this as any sort of medical opinion, just based on his observations that he made and how he would characterize the behavior of the defendant based on his observation.
All right. I'll allow it as long as you clarify it with him. Basically, the statement that you just made, I'd like you to clarify it with him in front of the jury, and then I'll allow that statement.
Your Honor, if I may.
You may.
Your Honor, I mean, even if it's his observation, under 403, Your Honor, the probative value is substantially outweighed by its prejudicial effect. It's going to mislead the jury. They've elicited this testimony multiple times, and he's not allowed and qualified to give a diagnosis of the defendant. And this is an extreme point in the case, and I believe it's going to mislead and inflame the jury, Your Honor.
And Mr. Marcus, I agree with you that he's not qualified. He's not able to do that. I do understand, though, that sometimes people can say the guy's acting crazy, and not saying as a doctor the guy's acting crazy, but just as a lay person saying that. And that's because I don't want to mislead the jury, and I agree with what you're saying. That's why I'm asking Mr. Allison to specifically state that. Ask the question to his officer that this is not in any capacity as a medical expert, but just your personal observations as a lay witness, or as a lay person, or as an officer.
Yes, Your Honor.
Is that clear, Mr. Allison?
Yes, Your Honor.
Okay. If you can ask that question, then that'll be admitted.
Yes, Your Honor. Officer Wentz, I'd just like to clarify for a moment. When you say that he's crazy and off his rocker, you're not offering that as a medical expert, are you?
No, I'm not positing any sort of clinical diagnosis. Just from my experience, this guy was absolutely crazy and off his rocker.
Okay, I appreciate that. And so why didn't you specifically request emergency medical attention?
Well, I thought that they would send one. I was kind of surprised when they didn't send one because of my reports. The guy seemed as though he was experiencing delusions throughout our entire interaction.
No further questions, Your Honor.
Okay, Mr. Marcus, you have an opportunity to cross-examine Officer Wentz, and you may take that opportunity now. Mr. Marcus, you're on mute. I'm sorry.
Thank you, Your Honor. Officer Wentz, I want to talk about something that you said on direct. You mentioned your opinion the defendant appeared to be suffering from some mental type episode.
Oh, it's not an opinion. He was suffering from a mental type episode.
Okay. You aren't allowed to, you're not a licensed psychiatrist, are you?
No, of course not. I've only completed the crisis intervention training.
You never treated patients with mental health issues?
No, I'm not a clinician. I'm a cop.
So other than the training you received in this limited police academy scope, you have no practical experience with mental health patients?
Well, practical would mean dealing with them on the street, and I dealt with Mr. Ray. So yes, I do have experience dealing with mentally ill patients.
And just to clarify, this was only 40 hours of training.
Yeah, that's a whole week. That's a full work week.
I want to talk to you about the night of October 20th, 2018. At that point, you've only been officer for about what, 2 years?
Yeah, 2 years.
And you were working a double shift that night, and I feel sorry for you, right?
Yeah, I was. It was actually my first double shift.
Yeah, and you know, as your first double shift, you must have been exhausted, weren't you?
Oh, they get to you. The double shifts get to you, but it's part of the job, and that's what we do.
But I want to talk more specifically about your interactions with the defendant on that night. You approached his car.
Of course.
You asked to see his license and registration.
After asking him to roll his window down and noticing that he was incredibly disheveled, I did, yes.
But he didn't give you his license at first.
No, he tried to pretend like he didn't have it.
In fact, he said he didn't have it,
Yes.
but you saw it sitting next to him.
Yeah, as I testified on direct, it was sitting right there in the front seat. He was clearly fibbing.
And you got his license and registration,
Yeah, eventually he reluctantly handed them over. Yes.
and you had your partner run this information.
Yes, I did.
You went back to the car,
Yes, I went to the car to deliver the information, of course.
but also because you wanted to watch him.
Oh, do you mean subsequent to delivering the information to my partner? Yes, I walked back over to Timothy's car.
And then you asked him to step out of the vehicle,
Yes, I did.
but he didn't.
No, once again, he was not very compliant.
In fact, he asked if you were CIA.
He did. He did.
You point to your badge.
Yes, I pointed to my badge and instructed him that once again, I'm an officer with the Skelton Police Department. This is a routine traffic stop.
So then you identified yourself as a skeleton police officer.
Yes.
And then after that, he never again asked if you were CIA.
No.
Then you
Not that I remember from our interaction. It was fairly brief.
And so you weren't able to memorize your brief interaction?
No, of course, I'm saying that no, not from my memory. I can't remember him asking me if I was CIA again after the second time.
And after he complied and exited,
Yes.
and as he was exiting the vehicle, he made some statements.
Yes, he did.
To be clear, you weren't questioning him at this time.
No, not necessarily. I was just trying to get him to comply with standard protocol.
So is that a no?
No, I wasn't questioning him at this time.
He was making those statements voluntarily.
Oh, yes.
He said, "I'm a good father. I didn't mean it."
Yeah, he said something along those lines. He said he was a good father and that he didn't mean it like 3 times. But it was weird because he was talking to no one. He wasn't conversing with me.
So he said that 3 times.
Yeah, to someone that wasn't there or no one at all.
Well, you were there, weren't you?
Yes, but he wasn't speaking to me. Just as you pointed out, I wasn't questioning him.
And you drove the defendant to the station for questioning.
Yes.
And on the way to the station, the defendant said, "I messed up."
Yeah.
He said he didn't mean to do it.
Right.
And Officer Wentz, I mean, be honest, at no point did the defendant claim to be hearing voices.
No, it looked like he was hearing voices. He was speaking to people that weren't there.
I'm sorry, maybe I asked that question a little weird. Officer Wentz, at no point did the defendant claim to be hearing voices.
No, but the defendant was speaking into thin air, nonsense into thin air.
So is that a no?
No, he didn't say it to me because he wasn't addressing me.
He never claimed to be seeing things
No,
and never mentioned that this voice made him kill his son.
not to me.
You thought Mr. Ray needed an EMT,
Yeah, I did just because it seemed like he was so off his rocker.
yet he's so off his rocker. At no point, though, did you ever request an EMT?
Not specifically.
No further questions at this time, Your Honor. May I moment to confer?
You may. You may.
No further questions at this time, Your Honor.
Okay. Mr. Allison, do you have a redirect?
Just very briefly, Your Honor.
Okay, go ahead.
Officer Wentz, you mentioned on direct that Mr. Ray was hearing CIA sirens. Were there sirens going on at that time?
No, once again, that just seemed like a complete delusion.
And when he stepped out of the vehicle and was making statements, was he talking to you?
No, it was like he was talking to nobody at all or someone that wasn't there. It was very strange.
No further questions, Your Honor.
Okay, Officer Wentz, you are excused. And I'll invite the defense to call their next witness.
At this time, Your Honor, the defense would like to call Dr. Shane J. Riley to the stand.
Okay, Dr. Major Riley, you have been sworn. And first of all, I guess, can we test your audio, make sure we can hear you?
Yeah. Hello,
Okay.
everyone.
Yes,
Are
perfect.
there any issues with the audio for anybody?
I don't believe so. And I didn't say this at the beginning, but if any of the jurors do have any issues with audio or anything else, you can just unmute yourselves and let me know, and we'll stop until everything fixes. But I think, Dr. Riley, I think everything's fine. So I'll invite Mr. Ephraim to begin your direct examination.
Thank you, Your Honor. Thank you, Your Honor. Please support. Dr. Riley, would you please state your full name for us?
Shane J. Riley.
And Dr. Riley, do you prefer Dr. Riley, Major Riley, or Dr. Major Riley?
Dr. Riley is fine.
Dr. Riley, what is your relationship to this case?
I'm the forensic psychiatrist brought in to evaluate Mr. Ray.
What does a forensic psychiatrist do?
Forensic psychiatrists focus on the relationship between psychiatry and the legal system.
Do you have a medical education?
Of course, I have a medical degree.
Please tell us about your education, Dr. Riley.
I received my medical degree from Edward Herbert School of Medicine at the Uniformed Services University at Health and Sciences in Bethesda. I then stayed in Bethesda for my residency and then my fellowship in forensic psychiatry at the Walter Reed National Military Medical Hospital.
So how long did you work in the hospitals, Dr. Riley?
For 10 years.
Could you tell us about your work then?
In 2006, I became the managing clinical psychiatrist at the psychiatric inpatient unit at the Walter Reed Hospital. Then in 2011, I became the deputy director of the behavioral health department.
So how long have you worked in the field of psychiatry now?
For 20 years now.
Have you ever taught within the field?
Yes, I was an associate professor from 1998 to 2001, and did it again from 2007 to 2010.
Have you written any professional or peer-reviewed articles in the field?
I've written 15 peer-reviewed articles in the field of forensic psychiatry.
Have you written about or studied schizophrenia specifically?
Yes, I have written 2 peer-reviewed articles on schizophrenia.
Are you on any medical boards, Dr. Riley?
Yes, I have been part of the American Board of Psychiatry and Neurology for the last 19 years.
Do you still work in the hospitals or are you teaching?
Not anymore. I've been in private practice for the last 5 years.
Dr. Riley, in forming your opinion, did you reliably apply principles and practices that are commonly used in this particular field?
Of course, my opinions in this report are made to a reasonable degree of medical certainty, in part based on the information and the knowledge I have acquired from my research, review of medical literature, my own personal experience in private practice, my education, my training, teaching, and interactions with the other psychiatrists.
Would you please tell us about your experience as an expert witness in the field of forensic psychiatry?
I have served as an expert witness in 25 previous cases. Some were court-martial proceedings, but the majority have been in criminal cases.
Your Honor, at this time, due to the court rules, we'd like to tender Dr. Riley as an expert in forensic psychiatry.
Okay, thank you, Mr. Ephraim. Ms. O'Connell, do you have any objection?
Yes, Your Honor, may we approach?
You may.
The state objects to tendering this witness as an expert in the field of forensic psychiatry and asks to voir dire this witness at this time. Outside
You
the
may.
presence of the jury.
You may, outside the presence of the jury, constructively.
Yes, Your Honor. Hi, Dr. Riley. You're a
Hello.
forensic psychiatrist,
I am.
a military forensic psychiatrist.
Correct.
That's a relatively new field.
Correct.
Your private practice is new as well, right?
Yes, 5 years old.
Your private practice is exclusive to veterans?
Not exactly.
Well, you'd agree that you opened this private practice to treat veterans with mental health disorders, right?
Yes.
And before you started your private practice, you served in Iraq.
Correct.
While there, you conducted a study.
Of course, with 20,000 troops.
A study only on military personnel, right?
Correct.
The results of that study only apply to those deployed?
Of course, you generally with science use a generalization of with the military itself, but some of these attributes can be taken to normal civilian life.
But you would agree, though, that the results of your study only apply to those who are deployed,
Generally so.
those deployed in Iraq.
Objection, Your Honor. I feel like this line of questioning is exhaustive. If the opposing counsel has questions that really point to Dr. Riley's inexperience, I'd love to hear them, but I'm confident that any more questions will leave them more than satisfied at this point for Dr. Riley's expertise, and anything beyond this point can wait till the cross.
I understand the objection. It is her voir dire and her time, and I will. I see where she's going, and she's trying to narrow the scope of what this doctor can, I guess, who this doctor can treat and what type of patient. So I'm going to allow her some leeway, but if she does get off track or you believe so, then go ahead and feel free to object again. I'll overrule for now.
Your Honor, Dr. Riley, I'll re-ask my question. That results of that study only apply to those deployed in Iraq, right?
I would say it applies to everyone in the military, not necessarily per Iraq itself.
Okay, well, the defendant was never deployed, you'd agree?
No, he did complete basic training,
But he never served in Iraq.
of course.
So he never really made it past basic training.
But basic training has its own stresses as well.
Dr. Riley, that's not what I asked you. I just asked you if he made it past basic training.
No, he did not.
I'll rephrase, Dr. Riley. The defendant never made it past basic training, did he not?
He completed basic training and that was it.
But he was never deployed.
No, correct.
Your Honor, the state objects to Dr. Riley being tendered as an expert in the field of forensic psychiatry because Dr. Riley is unable to satisfy the requirements under Federal Rules of Evidence 702. Specifically, Dr. Riley's knowledge, skills, and experience come from treating active duty personnel. In the present case, we're dealing with the defendant who was never deployed. He never served in active duty. And although that's what Dr. Riley is qualified in, that is not what we're here discussing today. Therefore, Dr. Riley does not have sufficient qualifications to be tendered as an expert in this case.
Do you have a response to that, Mr. Ephraim?
Yes. Am I unmuted? Yes. Dr. Riley has, through my questions earlier, shown that he has expert knowledge based on skill, experience, and training and education in the field of forensic psychiatry beyond just the scope of the military. It wasn't until he entered his residency and fellowship that he began to focus. On top of this, the expert's scientific, technical, and otherwise specialized knowledge is going to help the trier of the fact understand the evidence and determine the fact at issue here, which is Mr. Ray's mental health as he interacted with Mr. Ray in the military. This testimony is based on sufficient facts and data, and this testimony is the product of reliable principles and methods.
And Mr. Ephraim, I tend to agree with you, and I'm going to accept Dr. Riley as an expert in, you said forensic psychiatry?
Yes, sir.
All right, that is, he will be accepted. Ms. O'Connell, I will just tell you that I did find all of your questions relevant. If you were going to cross-examine, I do understand for the basis of time that you may not want to go through all those again. So I will say that they will have been constructively done in front of the jury in case you need to refer to that later on. Those questions will be considered to be in evidence. Okay, you're welcome. Go ahead. We're back in the presence of the jury. You may continue your examination.
Thank you. Dr. Riley, have you formed an opinion in this case regarding Mr. Ray's mental health?
Yes, I have.
What is your opinion?
Mr. Ray suffers from severe schizophrenia.
How confident are you in this opinion, Dr. Riley?
With medical certainty, Mr. Ray suffers from schizophrenia.
Why is Mr. Ray's diagnosis of schizophrenia relevant?
Mr. Ray's symptoms described in the materials I reviewed go back years before the need for any legal defense. They were consistent with the symptoms manifested in the months leading up to October 17th, 2018, through to my clinical interview of Mr. Ray.
Dr. Riley, I'd like to start by asking about your own interactions with the defendant. When did you first meet the defendant?
My first meeting with Timothy Ray was in 2010.
What were you doing in 2010?
I was a part of a small team overseeing 20,000 troops.
Would you please tell us about this interaction with Mr. Ray back in 2010?
Mr. Ray's commanding officer, who I had served with, had him committed for a psychiatric evaluation because he had caught him hallucinating, seeing things that were not there. Mr. Ray denied these hallucinations as well as suicidal ideation.
How long did you have him under your care?
Just 3 days.
And what did you diagnose him with then?
General anxiety disorder.
Why did you not diagnose him with schizophrenia at that point?
The Diagnostic and Statistical Manual of Mental Disorders, 5th edition, commonly known as the DSM-5, outlines the process to make a diagnosis for schizophrenia. There was not enough information or time in order to make a diagnosis of schizophrenia.
Since this first meeting with Mr. Ray, have you had the opportunity to fully evaluate Mr. Ray's case?
Yes, I have conducted a full evaluation in this case. I reviewed Mr. Ray's medical history, the arrest records, police reports, depositions, transcript of the preliminary hearing, and his primary doctor's reports, as well as interviewing those who knew Mr. Ray.
Thank you, Dr. Riley. But before we get into all of that, I would like to discuss malingering with you. Dr. Riley, would you tell the court what malingering means?
Yes, it is essentially the medical term for faking it so you don't have to go to jail. This is usually characterized production of false or exaggerated physical or psychological symptoms.
And what does medical certainty mean?
Medical certainty means I have the most confidence I can make in my own opinion.
Dr. Riley, are all schizophrenics violent?
No, they are not.
The ones that are violent, how can it manifest?
It will manifest through a display of violent tendencies such as angry outbursts or aggressive behavior.
Do all schizophrenics experience symptoms so severe that it impairs their ability to understand the nature of their actions?
No, some do experience this, but not all.
Dr. Riley, it's medically certain that some schizophrenics lose this ability to distinguish right and wrong?
Objection,
Yes,
your improper opinion may be heard.
You may be. Let me make sure I'm clear on the question. We'll go outside the presence of the jury.
Yes, Your Honor.
The question was,
Is it medically certain some schizophrenics lose this ability to distinguish right and wrong?
okay, Ms. O'Connell.
Yes, Your Honor. If we look to the case law provided in the packet on page 14, this provides that under 704, experts are not allowed to make a determination or testify about the ultimate issue in today's case. And
I agree, they are not.
Mr. Ephraim, we'll just allow Ms. O'Connell to finish, and I'll go to you for a response.
I apologize.
So
Go ahead.
under 704, experts are not allowed to make a determination or testify as to the ultimate issues in today's case. Opposing counsel asked this witness whether or not some schizophrenics have it so severe that they're unable to determine right from wrong. To allow this witness to answer that question is improper, and it is inappropriate for the jury to hear that under 704.
Okay, Mr. Ephraim, your response?
I refer the court to the excerpt from Pasquarello v. West Carolina that opposing counsel is citing, which states quite clearly that in trials where the defendant makes their insanity defense, as Mr. Ray has done here, the ultimate issue is whether the defendant appreciated the nature and quality of their acts. The question, as I will repeat, is not whether Mr. Ray was suffering severe schizophrenia that caused him to lose the ability to distinguish right and wrong. I was simply asking Dr. Riley whether he is medically certain and whether the medical field is certain that some schizophrenics lose this ability to distinguish right and wrong.
And you're saying that without applying it specifically to the defendant?
Correct.
Okay. Ms. O'Connell, can you respond to that?
Yes, Your Honor. I would just argue that under this case law, it clearly states that experts are only permitted to testify as to the characteristics of the mental health illness that they may be suffering for, cannot go to the ultimate issue of any determination as to the nature and quality of the actions or the right from wrong under 704A.
And I understand why you are why you're proceeding cautiously, and I understand the objection because it is close. However, I will let him testify about the general nature of schizophrenia and whether they can understand right from wrong. However, he will not be allowed, and Ms. O'Connell's objection is well taken, he will not be allowed to apply it to this defendant specifically on that issue. Is that, you understand that, Mr. Ephraim?
Yes.
Okay. And Dr. Riley, do you understand my ruling? Okay. So I will allow that question. I'm going to overrule. And
before we go back to the jury,
sure.
If I may ask the following question to see if we can just kill two birds with one stone here with opposing counsel. Is that
Okay.
all right? Or do you want me to ask it and then come back here if need be?
No, as long as we're here, that's fine. If she has an objection to it, what's the question?
I will ask Dr. Riley if he has discussed the morning of October 17th with Mr. Ray. And if he has, what his opinion is about Mr. Ray suffering symptoms consistent with severe schizophrenia that morning. Now, I argue again, I think we'll be back here under Pasquarello, that whether or not Mr. Ray is suffering symptoms from severe schizophrenia is not the ultimate issue. It's whether he knew right or wrong.
In Mr. Ephraim, and I can establish that now. I'll tell both parties that I am going to allow him to discuss specifically Mr. Ray's symptoms and whether or not that they correspond with schizophrenia, as I allowed the other expert to do. The only issue that I am saying that they can, and I think what goes under Pasquarello, is I will not allow him to say that Mr. Ray knew or did not know right from wrong at the time, specifically. However, the fact that schizophrenics may or may not know right from wrong is fine, and whether or not he has severe schizophrenia is fine. So if there's an objection, Ms. O'Connell, to that, I will overrule that objection. So,
Yeah, I have no objections to that, Your Honor.
all right, you will be free, Mr. Ephraim, to ask that question.
All right, please let me know when we return to the jury.
And we have back in the presence, you may proceed.
Dr. Riley, is it medically certain some schizophrenics lose the ability to distinguish right and wrong?
Yes, it is.
Have you discussed the morning of October 17th with Mr. Ray?
Yes, I have.
In your opinion, was Mr. Ray suffering from symptoms consistent with severe schizophrenia the morning of October 17th?
Yes, he was.
What led to this conclusion?
When we spoke about that morning, Mr. Ray stated he would do the same thing in front of an officer. He told me Nathan had to be punished. He's in a better place now. No more pain, no more suffering.
Dr. Riley, earlier you discussed the Diagnostic and Statistical Manual of Mental Disorders, what I'll refer to as the DSM-5, and I'd like to discuss that more. Do you and prosecution's expert agree that the DSM-5 is a reliable authority on schizophrenia?
Yes, it is the most reliable authority.
What criteria from the DSM-5 was relevant to your diagnosis of Mr. Ray?
3 of his symptoms: hallucinations, delusions, and negative symptoms, as well as what we term disturbances, Mr. Ray's medical history, drug history, and his hereditary factors.
Did you find any evidence of these criteria while evaluating Mr. Ray's case?
Yes, there was evidence for all of what I just mentioned.
How does Mr. Ray meet the hallucinations criteria?
He was having visual, but mainly auditory hallucinations.
How does Mr. Ray satisfy the delusions criteria?
Mr. Ray's paranoia regarding his wife's infidelity for at least 2 years, the voices of auditory hallucinations were pushing this idea when in fact they were not true, is a delusion.
I'm sorry, Dr. Riley, I thought auditory hallucinations were their own criteria and you just mentioned them in the same sentence as delusions. Would you please clarify that?
Yes, the voices are auditory hallucinations and satisfy that hallucination criteria. The delusions that the voices were giving him is still its own distinct symptom. It's just like one thing to hear something and the other to believe it.
Dr. Riley, how do phobias, a disheveled appearance, or poor hygiene relate to your diagnosis?
These are negative symptoms consistent with schizophrenia.
Could you please put the term disturbance into a medical context regarding the DSM-5's use of the word?
Yes, a disturbance is an event or occurrence in a schizophrenic's life that progresses their schizophrenia or triggers a psychotic episode.
Could military boot camp be a disturbance that brings on symptoms of schizophrenia?
Yes, it can.
Is it common to experience a psychotic episode stemming from a disturbance during one's early 30s?
It is atypical, but these common age numbers of onset psychosis being mid-20s for men and late 20s for women are not definitive cutoff ranges.
During the course of compiling your report, did you find any indication Mr. Ray had a substance abuse problem or another underlying medical condition?
There was no evidence of substance abuse or another medical condition.
And how does this factor into your diagnosis of Mr. Ray, if at all?
It satisfies the final step of diagnosis that Mr. Ray suffers from severe schizophrenia.
Were Mr. Ray's auditory hallucinations always the same?
No, they were not.
What was different about them?
In 2018, the voices began pushing the idea of committing a violent act.
Does the voices return coincide with violent acts?
Yes, they do.
Dr. Riley, you said earlier that you conducted interviews as part of the process of making your diagnosis. Who else did you interview in the course of forming your opinion?
I spoke with Mr. Ray's father, his ex-wife, and his former employer.
Why was it important to conduct these interviews with Mr. Ray's family and associates?
These interviews contain objective, firsthand observation of Mr. Ray's behavior, which are crucial to making and understanding a diagnosis of schizophrenia for Mr. Ray.
Are these interviews the type of materials that would regularly be relied on for making a diagnosis?
Yes, they are.
Let's talk about Mr. Ray's family history. Why was it important to discuss Mr. Ray's family history?
Hereditary factors and childhood traumas are informative when forming an opinion on whether someone suffers from schizophrenia.
Why are hereditary factors and childhood traumas relevant to or important to diagnosing schizophrenia?
They can increase the likelihood of someone suffering from a mental disorder. Some studies suggest that the risk of developing schizophrenia increases tenfold if a parent suffers from it.
What relevant information did you learn from your discussion with Abre, Timothy's father?
I learned about the loss of his mother at a young age. She had abandoned him and Mr. Ray when he was 3 years old. Mr. Ray's description of her symptoms were consistent with schizophrenia.
What happened to her?
She was institutionalized and died shortly after.
Dr. Riley, were you able to sit down with Timothy Ray to interview him in person?
Yes, I was.
Did you discuss his childhood with him?
I did.
What information relevant to your diagnosis, if any, did he tell you?
He reported hearing voices as early as the age 10.
Dr. Riley, we're going to move forward now to the years and the months leading up to October 17th, 2018. But again, real fast, I'm going to return to the DSM. Are relationships relevant to the DSM-5's process of diagnosing someone with schizophrenia?
Yes, it is. The DSM-5 discusses impairments that contribute to keep up with relationships, employment, and self-care.
And why was it important for you to interview Mr. Ray's former employer then?
I needed some firsthand observation of Mr. Ray's behavioral history to form an accurate diagnosis, and impairment of employment can be a potential sign.
What information did you find relevant to your diagnosis from this interview with Mr. Ray's former employer?
I learned that in April 2018, Timothy Ray was upset that his coworker was not following directions, so he slammed them against the wall and threatened their life.
What was happening in Mr. Ray's personal relationships leading up to 2018?
2015, he was experiencing auditory hallucinations or voices that told him his wife was cheating on him and that his wife and son were conspiring to cut him up with a knife.
Was she having an affair?
Not at that time.
How do you know that, Dr. Riley?
Miss Ray confirmed only in the months leading up to October in 2018 that she was actually having an affair.
Dr. Riley, could a spouse's infidelity be a disturbance that causes an episode?
Yes, it can.
Were there any third-party observations of Mr. Ray's illness?
Yes, there was from his ex-wife as well as his primary care physician, Dr. D. Giuseppe.
What did Jessica Ray report to you?
That Mr. Ray always had mood swings and would feel okay one minute and the next just couldn't stop crying. He became more isolated at the tail end of their marriage, locking himself in the bathroom for hours, refusing to come out, as well as going long periods of time without showering.
Was Mr. Ray always like this?
No, in 2017, Jessica said that he turned into just a completely different person.
Did Mr. Ray meet with any medical professionals in the years or the months leading up to Nathan's death?
Yes, between 2011 and 2017, he met with his primary care physician, Dr. D. Giuseppe.
Did you rely on the information that she reported in making your diagnosis?
Yes, I did.
What relevant information, if any, did you learn about Mr. Ray's visits?
Mr. Ray's second visit was made because of his mood swings. He reported anxiety, depression, but mainly it was about his marriage. Jessica had told him she would take the baby if he did not get help. When he told his doctor this, he started to cry for a while.
Dr. Riley, when was the last time Dr. D. Giuseppe saw Mr. Ray?
In 2017.
What relevant information to your diagnosis, if any, did you learn about this visit?
She thought Mr. Ray needed some serious treatment at this point. He looked and smelled like he hadn't showered in weeks. His hair was long and greasy, and she just described him as being a total mess.
Did Mr. Ray report any issues to her?
When she asked if he was okay, he replied, "No, I have never been okay." At this point, she asked him about any suicidal thoughts or harming others. He got very defensive and screamed at her, "Whose side are you on? What did she tell you? Have you been listening to my phone calls, you bitch?"
At this point, the defense passes the witness.
Okay, Ms. O'Connell, do you have a cross-examination?
Yes, Your Honor.
Proceed when ready.
Dr. Riley, I want to talk to you about your evaluations of the defendant. You evaluated him 2
Of
times,
course.
right?
Correct, in 2010 and recently in 2018.
Well, actually, it was 2019, right? Just to be clear.
2019. My apologies.
It's all right. And that was after he was murdered, after he was arrested. Sorry,
Yes, correct.
for murdering his son.
Yes, correct.
On direct examination, you also talked about malingering,
That
right?
is correct.
Malingering is when someone fakes their symptoms,
That is correct.
and malingering is always a possibility.
Malingering, of course, is always a possibility.
It's typically motivated by outside forces.
Can be.
It can be to avoid military duty.
Can be to avoid military duty.
It can also be to evade criminal prosecution, right?
Yes, of course.
Let's go through those one by one. You first treated the defendant when he was discharged from the military, right?
That is correct. Before his discharge, while seeing him inpatient.
That was back in 2010.
Yes,
And you diagnosed him with general anxiety disorder.
of course.
You did a full psych evaluation, right?
I did a full psychiatric evaluation at that time, yes.
You looked for any possible mental illnesses.
I did, and he did deny any severe mental illness at that time.
So you didn't diagnose him with schizophrenia.
Correct. I diagnosed him with general anxiety disorder and asked him to follow up with a therapist after his military service.
But he didn't follow up, did he?
He did not follow up.
And so you diagnosed him with general anxiety disorder, right?
That is correct.
That's a common complaint.
That is correct, especially in military service.
And it's suffered by 1 in 5 people, you'd say, right?
Roughly.
And then so in 2019, you evaluated him again.
That is correct.
He described exactly how he killed Nathan.
He did.
He told you that he strangled Nathan with a belt.
He did.
And before he did, he sat on his bed
Correct.
for a few seconds.
Correct.
He tried to calm down,
He did.
but he didn't.
He did not.
And you asked if he thought what he did was wrong.
I did.
And to that, he said, I had to punish him.
And that he would do it again in front of an officer.
And he also claimed that he heard voices.
Correct.
That
early as 10.
What was that, Dr. Riley?
As early as 10.
Exactly. He claimed he'd been hearing them for years.
Correct.
This is the first time, though, that you've ever heard about these voices.
At this time, yes, he did not give any evidence of voices in 2010.
That was the first time that you ever heard about any intrusive thoughts.
Correct.
You just said it before, Doctor. Malingering is always a possibility.
Always a possibility, but you must take into the other factors into account when deciding between malingering and schizophrenia.
But it's always a possibility, especially with serious crimes.
Of course.
The more severe the crime, the more likely to malinger, right?
I'm sorry, Ms. O'Connell, is there an objection, Mr. Ephraim?
Yes, I believe this has been asked and answered earlier in the cross-examination.
Okay, I'll overrule it on that.
I'll ask my question again, Doctor. Malingering is especially a possibility with serious crimes, right?
That is correct.
The more likely, the higher the crime, the more likely to malinger.
That's correlation, not necessarily causation. You must take into account the other factors, but yes, that is the case. The percentages increase.
But that was your statement before, right?
Yes.
And you can't be certain that this defendant wasn't malingering.
You can never be totally certain someone is not malingering. However, the facts of his schizophrenia outweigh that he is malingering.
But you can't rule it out, can you?
Correct, as with any differential diagnosis.
All right, so let's talk about why you thought this wasn't malingering. You were retained by the defense.
Correct.
In June of 2019.
Yes.
They paid you $6,650 for your work.
They did. I reduced my rate because he was one of my previous patients and also a veteran.
But you're also getting $1,500 to sit here today, right?
That is correct. Similar to what Dr. LaGreca is being paid.
And after you were retained, that's when you evaluated the defendant.
Correct.
And now you've diagnosed him with schizophrenia.
I had more time to evaluate my decision as he had more time to show his signs of schizophrenia.
So that's a yes to my question?
Yes.
You'd agree, Doctor, schizophrenia is rare?
Schizophrenia occurs with about 1% of people.
Less than 1% of the world suffers from it, right?
Yes, that's roughly 700 million people.
But it's treatable, right?
Not necessarily. There are treatments, of course, but there have been none shown to be truly effective.
But you'd agree, schizophrenia can be treated with different things.
Absolutely.
Therapy is one.
Therapy is one.
Antipsychotic medications is another.
Yes, that is.
But you didn't prescribe him either, did you?
At the time, I only diagnosed him with general anxiety disorder and gave him a medication, Paxil, which is commonly used for anxiety disorder.
Well, doctor, let's be clear. I'm talking about the 2019 after he was arrested. You didn't prescribe him either of those.
No, I didn't.
And Dr. LaGreca didn't diagnose him with schizophrenia, right?
No, she did not.
Neither
But
did
she
the
did not
jail
interview him
doctor.
personally. Oops, sorry.
What was that, Dr. Riley? You can.
Sorry, I cut you off.
That's fine.
No, go ahead.
The jail doctor didn't diagnose him with schizophrenia.
No.
Neither did the family doctor.
No, she did not, but she only met him on 3 occasions.
But that's a no to my question. She didn't diagnose him.
No, I said no, she didn't. She only met him on 3 occasions, though.
You only met him on 2, though, right?
I met him twice, once in 2010 and once in 2018.
And not even you diagnosed him 10 years ago.
10 years ago, he wasn't exhibiting his signs of schizophrenia.
He didn't tell you them either, did he?
He did not at that time.
He didn't mention any of it?
No, he did not mention any of it.
And he wasn't being charged for the murder of his son back then?
Of course not. He didn't have a son yet.
And you were here when Dr. LaGreca testified.
I was.
He testified he wasn't allowed to evaluate the defendant.
Yes.
So only you were allowed.
Correct.
And only you diagnosed him with schizophrenia.
Correct.
A moment to confer, Your Honor.
You may.
I have no further questions, Your Honor.
Okay. Any redirect, Mr. Ephraim?
Yes, briefly, Your Honor.
Okay.
Dr. Riley, back in 2010, was it your job to evaluate?
Yes, it was.
Was it your job to treat?
It was at that time in 2010.
Your job was to treat the defendant?
In 2010, to treat him with anxiety disorder.
And let's talk about since then. Have you had the opportunity to fully evaluate Mr. Ray?
Yes, I have.
During prosecution mentioned the doctor at the jail has not diagnosed him with schizophrenia. Do you know if Mr. Ray has been prescribed any medication?
He has been prescribed some medication.
And what has he been prescribed?
I don't remember.
Would it help you to refresh your recollection if you were able to view?
Yes, it would.
Dr. Riley, I'll have you turn to your report, which I believe is marked exhibit. Exhibit 11.
Mr. Abram, could you refer us to the page number from the electronic? Is there a page number?
Yes, I'm pulling that up right now. I
The
apologize.
report starts on page 58, Your Honor.
Thank
Page
you.
15. Thank you.
What medication was he prescribed?
Oh, I can't. In 2010 or 2018?
In 2018, since his arrest.
I cannot find it. I'm drawing a blank. He was prescribed an antipsychotic medication. Of the name, I'm uncertain.
And this medication that he was prescribed, what can it be used to treat?
It can be used to treat schizophrenia.
And back in 2010, when Mr. Ray's commanding officer caught him, did you believe his commanding officer had really caught him hallucinating?
Objection or irrelevance?
Your Honor, they brought this up on cross. I'm merely referring back to Dr. Riley's diagnosis of Mr. Ray back in 2010.
Maybe heard
I think if I can be clear, you're objecting the relevance of his belief. Like, why is it relevant what he believed?
Yes,
so, Mr. Ephraim, if you can respond to
that. Your Honor, the Dr. Riley has testified that he served with Officer Cruz was his name, the commanding officer. And I am wanting to, they had a personal history, as Dr. Riley mentioned, that he served with him. So I am asking if he believed him because of Officer Cruz's, and are we, before I continue, are we away from the jury?
Sure, we'll go outside the presence. Thank you.
That Officer Cruz had a history of exaggerating. And so I wanted to confirm with Dr. Riley that even though he has served with him, that he, I wanted to know whether or not Dr. Riley took him at face value on his statements.
Okay. Can you, I guess you said that Ms. O'Connell brought that up on cross-examination. Did she bring up Officer Cruz's observations on cross?
No, that was Dr. Riley's, Dr. Riley during his direct referred to his history with Officer Cruz that he served with.
Okay, and what's your response, Ms. O'Connell?
I would argue that what Dr. Riley believed in relation to anything in his evaluation is irrelevant. He can testify as to his observations and what he conducted during that evaluation. But further, I would argue that that was outside the scope of my cross-examination. I didn't go into anything about Officer Cruz, and if opposing counsel wanted to cover that, they should have in their direct examination.
Well, I'll sustain as to the relevance of the belief. However, I will allow you to redirect on the issue, but as to his belief about whether he believed him or not, I'll sustain the objection to relevance.
Thank you.
We're back to the jury. Yes.
Dr. Riley, did you end up discharging Mr. Ray from active duty back in 2010?
Yes, I did. I discharged him with a prescription for Paxil and advice to seek further assistance from psychiatrists or psychologists.
And would you please remind the court of your opinion of Mr. Ray's health?
Objection or asked and answered.
I'll overrule.
That he was suffering from severe schizophrenia.
Could believing your child is turned against you be a disturbance that causes a psychotic episode?
Objection or asked and answered.
I'll overrule.
Again, I'll ask, could believing your child is turned against you, Dr. Riley, be a disturbance that triggers a psychotic episode?
Yes, it can.
No further questions.
Okay, Dr. Riley, thank you for being here. You are excused. We have now come to, well, I guess I'll ask the defense. Do you have any further witnesses?
No, Your Honor.
Okay, does the defense rest?
At this time, the defense rests their case, yes.
Okay, we have come to the point of closing argument. So let me go to my little instructions here. So we're going to now hear closing arguments for each party. Everyone, please switch back to speaker view so that our scoring judges will be able to see each speaker. Is there a need for any short amount of time to set up any technology, or is everybody ready to go?
Your Honor, may I request about 1 to 2 minutes just to set up as demonstrative?
Sure, you can have 2 minutes.
Thank you, Your Honor.
Your Honor, at this time, it does look like we have a time discrepancy. If it's possible to take that up at the court now before entering into final arguments.
Sure. What is the discrepancy?
We just needed to clarify on a rule because we do have a 52-second difference. It happens during voir dire, during Ms. O'Connell's voir dire of Dr. LaGreca. Her argument at the end after asking her questions, would that be counted against her time, or is that considered an objection?
That would be considered an objection.
Okay, so we would request that we would follow the prosecution's time for that specific argument.
Well, let me ask the defense, is that the only discrepancy, is the 52 seconds of that argument?
Yes, Your Honor. That was the only thing that was unclear. It wasn't in the trial rulings, so we just want to make sure we were clear on that.
Yeah,
it was only the questioning.
Yes, sir. I considered after she stopped questioning and then went back to arguing the objection, I considered that to be a part of the objection and not counted towards her time. So what is, I guess, now that we know, what is the, what time is remaining for the prosecution and the defense?
The prosecution has approximately 12 minutes and 13 seconds.
Okay. And the defense?
We've used exactly 40 minutes and 1 second, so about 15 minutes remaining.
Okay. I think that should be well enough time for each advocate to display their prowess in front of these judges. So if we can all agree to that, then the prosecution will have 12 minutes and 13 seconds and the defense will have 15 minutes to do their close. Mr. Marcus, are you ready?
Yes, Your Honor.
Okay, then I will invite the prosecution to give their closing argument. Do you need, I know you don't have to reserve any time, but do you plan on having a rebuttal or using your remaining for rebuttal?
Yes, I do, Your Honor.
Okay, you will be allowed whatever time you have left to do rebuttal. I'll just ask that whoever is the timekeeper, just let me know how much time is left so that I know how much time the rebuttal is. And other than that,
Understood, Your Honor.
Okay, you're free to proceed then.
May it please the court, counsel, members of the jury. Punishment was his priority. He knew it was wrong. He knew it when his wife had an affair. He knew it when his coworker disobeyed. And he knew it when he murdered his 6-year-old son, Nathan Ray. When he was tightening that belt tighter and tighter and tighter. But make no mistake, members of the jury, we understood our burden when we walked into the courtroom today. We understood that we must prove that this defendant killed Nathan Ray beyond a reasonable doubt. A reasonable doubt is not one that's speculative. It's not one that wavers. Remember, you're not here to search for doubt, but you're here to search for the truth. And in a few moments, members of the jury, you're going to receive a verdict form. It's going to ask you whether this defendant is guilty of the first-degree murder of his son, Nathan Ray. Now, no one here is arguing that the defendant killed his son. All we have to prove is that the defendant killed his son with premeditation. The definition that this court uses for premeditation is the decision to kill after a period of reflection. This period has no certain length of time. It doesn't have to be days, doesn't have to be hours, but it can be mere seconds. And that's why we've met this burden today, because we have walked you through the truth of these events. You heard today from Dr. Greca and Major Riley that before that defendant wrapped that belt around Nathan's throat and pulled until he stopped moving, he took a moment to stop and think about what he was doing. You see, you heard that he walked back to his bedroom, he sat on his bed, and for a few seconds he considered whether he wanted to kill. See, he couldn't stop his wife from having an affair. He couldn't stop from being discharged from the military. But what he could stop is his son from disobeying ever again. But you must also understand that strangulation is not a quick manner of death. He had from the time that he wrapped that belt around Nathan's throat to the time that he pulled until he stopped moving, until he stopped breathing. But you see, punishment was his priority. But we're not the only party that walked into the courtroom today with a burden. The defense has a burden to prove to you today as well. The defendant has raised the insanity defense, and what this means is that they must prove by clear and convincing evidence that the defendant did not understand the wrongfulness of his actions when he murdered his son. They have to convince you that it is substantially more likely than not that one, not only did he suffer from a severe mental illness, but two, he was unable to appreciate the wrongfulness of his actions when he took the life of his son. And as you are well aware by now, members of the jury, that is something that they were unable to do today. But let's take a step back. Let's talk about what we do know. We know from the evaluation conducted by Major Riley in 2010 that he only concluded that this defendant suffered from generalized anxiety disorder. We know from the experts that this is highly prevalent in military personnel. In fact, we know from the evidence that 1 in 5 Americans suffer from this. And once he was determined not to be suffering from this, he was released, discharged, as he was not a threat to himself or to others. Never was he diagnosed with any form of schizophrenia. But we also know from the second evaluation conducted by Major Riley in 2019 that this was the first time we heard about schizophrenia. This was the first time that he was diagnosed with schizophrenia. And it happened to be in the same report that Major Riley told you that they want a favorable outcome in this case. Major Riley never prescribed him any medication consistent with an individual that suffers from schizophrenia. But a better question is, and you heard here today, is that the defense didn't allow our expert, Dr. Greca, to interview the defendant. Ask yourselves why. Why not just let Dr. Greca interview the defendant? Because we know why, members of the jury. Because in 2 seconds, Dr. Greca would have known that this defendant was malingering. Because he already knew it on paper, let alone an interview. Because at this point, when he was stopped at that sobriety checkpoint, he knew he was in trouble. And when the officers walked by his car, they saw the shovel, they saw the bleach, and they saw the trash bags, he knew that he had to fake his symptoms because Nathan Bray was reported missing, nowhere to be found. And he knew that at this point, he had to be insane. But to also prove this, let's look to the factors of malingering. The first factor is that the more serious the crime, the higher the likelihood that an individual is malingering or faking his symptoms. In this case, the defendant had significant incentive to fake his symptoms because he is charged with the first-degree murder of his son. But let's also look to the second factor, any marked discrepancies in his behavior or symptoms associated with schizophrenia. And we know there to be major discrepancies in the symptoms that we saw in the police evaluation and the symptoms that we saw in the evaluation conducted by Major Riley compared to the objective findings found 10 years prior to the killing. Because back in 2010, he was denying any observations related to his diagnosis of schizophrenia. And he was only diagnosed with generalized anxiety disorder. But now they want you to believe, opposing counsel wants you to believe that he's been suffering from these since he was 10 years old. Members of the jury, these are marked discrepancies. But the third factor is also the failure to cooperate. And not only did Mr. Ray fail to cooperate in his evaluation conducted by Major Riley in 2019, but he failed to cooperate with any prescribed treatment regimens in the 2010 evaluation and in the 2019 evaluation. Finally, we look to whether there was any presence of antisocial personality disorder. And we know that they was never diagnosed with any presence of this. However, you have to look, if there's any combination of these factors which are present, which the evidence has shown you today they are, it is more likely than not that this defendant is malingering, that he is faking his symptoms. But if that is not enough, even if you believe he suffered from a disease that was never diagnosed, that was never observed, that was never portrayed, remember, simply having a severe mental illness is not enough to be found not guilty by legally insane. you must also not be able to understand right versus wrong. And we know that Mr. Ray consistently justified his actions and covered up his tracks. This shows that he understood the wrongfulness of his actions on October 17th, 2018. You saw here today the defendant's phone searches from the day after Nathan was murdered. And what better way to prove a point than use the defendant's own words against him? The defendant was searching on his phone countries that don't extradite for murder, how to get rid of a body, and will bleach destroy a body? You might be sitting there asking yourselves, why is this important? Mr. Jury, this is important because we found the bleach in the car, next to the trash bags that Nathan's body was wrapped in, next to the shovel that was used to dig a shallow grave that his body was thrown in, because he knew this was wrong. And even if he did suffer from severe mental illness, which we know he didn't from our expert, Dr. Greca, he understood the wrongfulness of his actions on October 17th, 2018. But let's also look to the time that he took to reflect. That when he went to his room, as you heard, sat on his bed for a few seconds, he deliberated. He considered whether he wanted to kill. Not just because it goes to premeditation, but because he understood that these actions were wrong. And that, members of the jury, is why he's not legally insane. We are confident that when you analyze the facts and all the testimony and all the physical evidence presented to you today, you're going to reach a verdict that the evidence compels and that justice demands. A verdict that shows on October 17th, 2018, punishment was this defendant's priority. Find this defendant guilty of first-degree murder.
Okay, thank you, Mr. Marcus. Can I get a time check of how much he has left for rebuttal?
For rebuttal, we have 3 minutes and 21 seconds remaining.
Okay, thank you. Okay, defense.
Yes, Your Honor.
There you are. Mr. Allison, I invite you to give your closing argument to the jury, and you may proceed when ready.
Thank you. May it please the court, opposing counsel. On October 17th, 2018, Timothy Ray could no longer fight his schizophrenia. As his family life deteriorated, the voices dictated his reality, and he could no longer tell right from wrong. The reality of Mr. Ray's family being taken away from him was becoming more and more real, just like the voices in his head. His wife was having an affair, just like the voices said that she would. And as the line between what was real and what was his delusions became more and more blurred, the voices had an easier time dictating his reality until finally on October 17th, 2018, Mr. Ray could no longer tell right from wrong. Because the voices were dictating Mr. Ray's reality, when Nathan Ray spilled juice on his father's laptop, it caused Mr. Ray to snap. And this snap was accurately diagnosed by Dr. Riley as a psychotic episode. And this psychotic episode made Mr. Ray find the need to discipline his son. And he started this discipline by making him do physical exercises, high knees, jumping jacks, and running in place. But these simply didn't work. And as the voices dictated his reality, they gave a command to kill his son. And Mr. Ray went to his bedroom and grabbed a belt. But when Mr. Ray left his bedroom to go back to Nathan, he was no longer in control. The voices completely dictated his reality, and he could no longer tell right from wrong. So we all know why we're here today now. We are here because Nathan Ray was murdered, and his father committed that murder. And you'll have noticed that my co-counsel and I haven't disputed those facts, but we're here to present a more complicated question. We're here to ask the question, how did we get to this point? How did we get to the point where a father who clearly cared about the well-being of his child, as evidenced by him making Nathan his favorite bowl of cereal and pouring him a glass of juice could in a matter of minutes go to wrapping a belt around his neck and strangling the life from him. Clearly, that's not the progression that a sane father would make. But we now know that Mr. Ray is insane, and that's exactly what happened today. In order, my co-counsel and I had to prove to you two things by clear and convincing evidence today. We had to prove to you first that Mr. Ray suffered from a severe mental disease at the time he murdered his son. And second, that Mr. Ray, because of that severe mental disease, was unable to appreciate the quality and nature of his actions, or that he was unable to appreciate the wrongfulness of his actions. And we have proven those things to you today. We first showed you that Mr. Ray was suffering from severe schizophrenia when he murdered his son. In fact, he's been suffering from severe schizophrenia for a long time. He first reported to Dr. Riley that he heard the voices at first when he was 10 years old. And we also know from Dr. Riley's testimony that his mother was abusive and neglectful and left him when he was 3 years old. And then after she left, she was institutionalized with her own severe mental illness. And when Dr. Riley examined the interviews that described those symptoms of Mr. Ray's mother, he concluded that they were consistent with a diagnosis of schizophrenia. And this is significant because, as Dr. Riley told us, having a parent with schizophrenia greatly increases that child's chances of also having schizophrenia, just like it happened in Mr. Ray's case today. But that's not all the evidence we have. We also know when Mr. Ray joined the military that his commanding officer, Thomas Cruz, reported him to be discharged because Mr. Ray reported to Officer Cruz that he was experiencing visual hallucinations. And while Dr. Riley did not diagnose Mr. Ray with schizophrenia at that point, it was not because Dr. Riley missed something, it's because Dr. Riley was following his orders. He was in command and responsible for the mental health of 20,000 troops, and he had to decide whether or not they were fit for military service. He decided that Mr. Ray was not fit for military service. But the significant part of this interaction is that Mr. Ray's symptoms were still severe enough that he had to be institutionalized for 3 days. He spent 3 days in the hospital because of his own mental symptoms. We get more evidence of Mr. Ray's mental illnesses and his schizophrenia when he assaulted one of his coworkers. He assaulted one of his coworkers at the same time that the voices returned, and this time they were pushing violent thoughts to him. They were pushing a violent agenda. Mr. Ray acted on these violent suggestions when he assaulted his coworker. But perhaps it is most clearly seen Mr. Ray's schizophrenia through his interactions with his own family. Jessica Ray told Dr. Riley that throughout their entire relationship, Mr. Ray had always suffered from mood swings. But towards the end of their relationship, he would occasionally lock himself in the bathroom for hours, and he would sometimes go a whole week without showering. We also know that the voices were telling Mr. Ray that his wife was cheating on him 2 years before she ever gave him reason to believe that. And they were also telling him that his wife and son were conspiring to cut him up with a knife and leave him. Now, obviously, these voices had a severe impact on his relationships, to the point where Jessica Ray was cautious enough to tell Mr. Ray that he needed to go get serious mental help, or that she would take Nathan and leave him. And Mr. Ray did go to Dr. DiGiuseppe, his general care physician. And Dr. DiGiuseppe also noticed Mr. Ray's poor hygiene, just like Jessica Ray did. And she asked Mr. Ray if he was okay. And Mr. Ray responded by saying that he had never been okay. And unfortunately, Mr. Ray did not get the help that he needed from Dr. DiGiuseppe. But that's because when the voices are in control of your reality, not even your doctor can be trusted, which is why he accused Dr. DiGiuseppe of listening to his phone calls, of talking to his wife, and he even called her a bitch. We also know from Officer Wentz more of what Dr. Riley called negative symptoms. Officer Wentz described Mr. Ray as unkempt, dirty, disheveled, and that he stank. And these are clearly signs of negative symptoms because we know Dr. Riley told us that they were. We also know from Officer Wentz that Mr. Ray was terrified he was being followed by the CIA. And this might help us put into context those internet searches just a little bit better. Because after all, what would the CIA do with Mr. Ray if they found out that he had murdered his son? Now, I know you also heard from the prosecution's expert, Dr. LaGreca. And Dr. LaGreca told you that Dr. Riley's findings were incorrect. But here's what's important about Dr. LaGreca's testimony. Dr. LaGreca never talked to anyone that knew Mr. Ray. Regardless of whether or not he talked to Mr. Ray, he never talked to anyone else. Instead, he relied on the interpretations and the summaries of the interviews that Dr. Riley conducted and came to a different conclusion. And of course he did. Because if he didn't come to a different conclusion, he wouldn't have been here testifying, being paid to testify to you today. The fact is clear that Dr. Riley did all of the work in this case to diagnose Mr. Ray, and that's why his opinion is the correct one. Now, we also had to prove to you that Mr. Ray didn't appreciate the wrongfulness of his action, and we know that he didn't think that what he did to Nathan was wrong, because Dr. Riley asked Mr. Ray in his clinical interview whether or not he thought what he did to Nathan was wrong. And Mr. Ray responded by saying that he thought Nathan was in a better place. No more pain, no more suffering, better there than here with no mama or papa. And Dr. Riley asked a follow-up question whether or not Mr. Ray would do the same thing if a police officer was watching. And Mr. Ray responded that he would. And we know that that's insane because normal people don't even speed when they know a police officer is watching because they know speeding is wrong. But we know that Mr. Ray thought what he did was right. He believed that he did the best thing for his son by putting him in the ground and strangling him to death. And we know that that's not right. So it's clearly indicative that Mr. Ray didn't appreciate the wrongfulness of his actions. Now, I'll leave you with this. I know that the prosecution told you that punishment was Mr. Ray's priority, but that wasn't his priority. Punishment is the prosecution's priority. Your priority should be justice. And justice asks you to do something very hard sometimes. It is asking you in this case to take the facts as they've been given to you and apply it to the law. And the law is clear on this, that if you find by clear and convincing evidence that Mr. Ray was schizophrenic when he murdered Nathan, and that schizophrenia led him to not be able to appreciate the wrongfulness of his actions, then you must find Mr. Ray not guilty by reason of insanity. And we know Mr. Ray was suffering from schizophrenia. He'd had schizophrenia since he was 10 years old. He had schizophrenia when he was in the military. He had schizophrenia when he assaulted his coworker, and he had schizophrenia when he murdered his son. We also know that he didn't appreciate the wrongfulness of his actions because he truly believes that his son is in a better place and that he did the right thing for Nathan. And we know that that's indicative of him not being able to appreciate the wrongfulness of his actions because fathers shouldn't strangle their children over spilled juice. Which is why I'm asking you today to please return a verdict of not guilty by reason of insanity. Thank you.
Okay, thank you, Mr. Allison. Mr. Marcus, do you have a rebuttal?
Yes, Your Honor.
Okay, go ahead.
May it please the court, counsel, members of the jury. Your job isn't to ask questions, but to prove their burden. They only brought you questions that they left unanswered. In the next minute or so, I'm going to answer these questions for you. They said that he was hospitalized after his diagnosis, only for 3 days. 3 days in the hospital, for we know that Major Riley diagnosed him as general anxiety disorder. But they're claiming that his schizophrenia was so severe that he was only hospitalized for 3 days. That just doesn't add up, members of the jury. They also added, how did we get to this point? But let's take the facts and I'll apply them to law and tell you. Now we know that he admitted that he took the time, that he premeditated the death of Nathan. We know that he walked back to his bedroom, that in a few seconds, he sat in his bed and considered whether he wanted to kill. In his own words, we know that this was enough time according to jury instructions. Premeditation doesn't have any certain length of time. It doesn't have to be days, like I said, it doesn't have to be hours, but it can be seconds. And he took these few seconds and considered whether he was going to move forward with his actions. This establishes premeditation. But we also know that he got the supplies in furtherance of this. We know from his text messages that you saw on the defendant's phone and his Google searches, that showed countries that don't extradite for murder, how to get rid of a body and will bleach, destroy a body. Someone doesn't go get the supplies. A person doesn't go get bleach or trash bags or a shovel. Does an insane person do that? No. He sat down and he searched where he wanted to go, how to get rid of the body, and will bleach destroy a body. And we know that this is important because we found the bleach in the car, next to the trash bags and next to the shovel. They also bring up the fact that our expert was never able to talk to Mr. Ray. But we know from our expert and from the evidence that he wasn't able to talk to Mr. Ray because the defense didn't allow it. Ask yourselves why, like I said. Why would they not let him? Why would they not let Dr. LaGreca interview the defendant? They wouldn't let this because they knew that their client was malingering, that he was faking the symptoms. And they also talk about the unbacked conclusions that they made about schizophrenia, that he was suffering when he was 10, that he was suffering in the military, and that's suffering now. But this just isn't true. We know that there's marked discrepancies, that we never heard about any of these symptoms in the years prior to the killing. He was never diagnosed with schizophrenia when he was in the military, only generalized anxiety disorder. And now, as our expert has shown you today, he's not suffering from schizophrenia today, and he was able to understand whether his actions were right or wrong. Find this defendant guilty of first-degree murder.
Okay. Thank you, Mr. Marcus. All right. Congratulations, advocates. That was a great trial. I do have some instructions for our jurors. I'm going to go back to gallery view so I can see. Okay, so we have closed, and so the jurors, you guys are, I know that y'all have been given instructions about how to fill out your ballots. So if you could please do that now. All the advocates, y'all mute yourselves and video. And then once you have finished, we will have an opportunity for each judge to give some brief comments to each team. I think it's going to be limited to one comment per judge, so make it good. And and I'll let them know we're finished. And once you guys put in the ballots and they get in, they'll tell me that we can start the comment section. And I guess judges, when you complete the ballot, if you could just put in the chat to everyone, or just say that you've completed it so that I know. Okay, it looks like I have all three. Perfect. Okay, so I just need a little bit of time. They're going to give me the all clear that they have received everything, and then we'll start with the comments. Okay, I've received the all clear. So I guess the way I'll do it is we will start with how you guys told me that your ballots were completed. So we'll start with Ms. Pearson. I guess if you could tell them, tell our advocates, everybody turn on your cameras so she can see you. If you can just tell them who you are and then give them I guess a brief comment to each team about what you liked or what they may need to improve on or something that you noticed. You're on mute, ma'am. I'm sorry.
I'm on mute and steady yapping away. My name is Brianna Pearson. I'm a solo practitioner in Philly and a Drexel Law School alum. I coach my trial to high school students, so I love any chance that I can get to judge a trial team. And I thought you guys were fantastic. Just, I guess, just to give quick feedback. Megan, I thought your opening was amazing, was very strong. You laid out what you intended to show very, very concisely. Defense, Alex, I thought your objections to certain evidence that the prosecution wanted to introduce was right on point. And kind of narrow down what you wanted to be presented. Graham, I thought your closing was phenomenal. It was very succinct. You really showed what you intended, for the jurors to see and know and hear. And overall, I think you guys just really did a phenomenal job.
All right, that's great. Thank you, ma'am. And now, Ms. Nielsen, what comments do you have? And just let them know a little bit about who you are.
Hi, I'm Maggie Nielsen. I'm a Colorado attorney, mostly do family law, but I'm actually living in British Columbia right now. And I totally agree with all the previous comments. You guys did a great job. Just since it's round one, I will say I think it'd be great if the defense for future rounds just had a little more command on cross. And for the prosecution, if you guys, I know nerves get in the way of this, make it so hard, but if you could work on just having a little more vocal variety in your pitch and tone and inflection, I think in all your memorized stuff, in unmemorized stuff, you guys were really confident and on top of, know your stuff. So bring that more to the memorized content. But great job, everyone. You guys did a great job.
Thank you very much. And that's good advice. And I agree with what she said as well. Mr. Liss, last but not least.
Hi, everyone. I'm Perry Liss. I am the managing partner of a small real estate related civil litigation firm in Philadelphia. I graduated Drexel Law in 2009. And I apologize if you hear my 5-year-old running around in the back. There you go. So first, I thought it was great from everybody. I really enjoyed the preparedness. It was clear that you all worked really hard on this. I did move forward. Like I know the nerves that get in the way, and I didn't really show with any of you. I thought you were all really like deferential to the judge and very well mannered, which I think is important, specifically with judges, because they think that they deserve it. And I enjoyed that you had a lack of like trivial objections. A lot of time people will object to everything, and I think that you kind of withheld it for the things that you thought mattered, and I think that that's good. I think that emotions really matter in jury trials, and they didn't really reflect that on your face. Like, Graham, your closing was really great, except you're smiling when talking about a child being murdered. And I think if you're in front of a real jury, they would react. I'm not. I'm just judging you on what you're saying, but that's something you want to keep in mind. And I thought the same for Trey. I thought your closing was good, but I think you need to recognize the fact that if you're talking to a jury and a child gets murdered, that matters. And you have to do your job and defend the guy and prove that he's insane, but you might want to recognize the fact that there was a tragedy that happened regardless. A couple other things besides that. I'd be careful in attacking, this was for Megan, who I thought was great across the board, attacking a Army vet. Juries and judges probably will not love that very much, especially if they're a vet. But other than that, I really think you guys did great. Alex, the one thing I want to say about you, you didn't panic. You asked someone to refresh their recollection. Sometimes people will panic when a witness doesn't give them the answer that they thought they were going to get. So I think you all handled yourselves really well. I was very impressed, and I enjoyed being here.
All right. Well, I would like to thank our jurors who are our judges. We really appreciate your time. We know, obviously, I'm a coach actually for another team, and I guess y'all know that. But as a coach for another team, I want to say how much I appreciate y'all being here to evaluate them. And that's it for the trial. Y'all did a great job. I was really impressed with everybody. So you guys can log off now, and I'm going to shut down the courtroom. So thanks, everybody. Appreciate it.
Thank you.